testing, 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 test, 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 test.
I'm great. How are you? Boy, I tell you, I love to wake up and
Testing, test. Test, test. Test, test, test. Test, test. Test, testing, test.
I don't know the history.
Test, 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 test.
Push, it'll turn green when it's green, it's ready.
Okay.
When you're done. I don't think I'm gonna say.
I'm good.
Yes, we did. We came in last night. Had some dinner. I have actually. So you come from this game.
Mark, ooh, it's a very good idea. You're on the fence, man. A little out of order. Is anyone here today for public comment? Make a public comment. Okay. Someone raise your hand. Okay. We have a sign-up sheet. If you wouldn't mind signing the sheet, please. Are we good? Start. Good morning. We will start the June Oil and Gas Conservation Commission hearing in Meeker. It was a lovely drive here for many of us. Beautiful spring weather, a lot of green. It was a wonderful and enjoyable drive. Before we do the roll call of commissioners, I'm going to introduce our two new commissioners and say a few words, and I think then Mr. Randall may want to say something, as well as Director Lepore when they have their opportunity. First is Erin Overturf. Is that pronounced correctly? She has been appointed to the commission for her significant environmental experience. And secondly, Howard Boygan. I think I got that right as well. He's been appointed for significant oil and gas experience. Would like to thank both of them for their willingness to serve and to bring their experience to this commission. It's a fair amount of a time commitment to do this, and very much appreciate your willingness to step forward and to serve as commissioners, and welcome. With that, I will turn it over to Mr. Gowan for the roll call.
Okay, Commissioner Ager. Commissioner Benton.
Here.
Commissioner Boygan.
Here.
Commissioner Hawkins.
Here.
Commissioner Holton is not here. Commissioner Jolly.
Here.
Commissioner Overturf.
Here.
Commissioner Randall.
Here.
And Commissioner Wolk.
Here.
We do have a quorum.
I think our next item is a report from the Executive Director's Office. Briefly before we do that, just a general reminder that if you do have one of these handheld devices, please make sure it is silenced.
Okay.
Wouldn't want to interrupt Mr. Randall.
Thank you, Mr. Chair. Again, Bob Randall for the department. First, I just want to extend my thanks to Rio Blanco County for hosting us here in Meeker and for letting us use the county building here. It was a beautiful drive up, and always good to be here in the Piance, home to so much of the activity that we oversee and have overseen for a long time. I likewise want to extend my welcome to the new commissioners, Commissioner Boygan, Commissioner Overturf. Thanks for your service. Thanks in advance for all of the time that you're going to put into this commission. It is incredibly rewarding, important work that we do for the public here. And, they call people who work for government public servants, but truly the service that we benefit from is a service from the volunteers that want to do this. So thank you in advance. Given that our last hearing was right before the end of the legislative session, I'm going to give just a quick update on that and sort of a postmortem. Like everything in the General Assembly, you win some and you lose some. And given that there's an entire industry surrounding killing bills, winning some often means something not occurring, if that makes any sense. So just a couple of things I want to touch on. One, a priority bill for the department that didn't make it was the Parks and Wildlife Financial Sustainability Bill. This is a bill that would have given the Parks and Wildlife Commission the ability to, the authority to raise hunting and fishing license fees for residents. Currently, that's set by those fees are set only by the General Assembly. They were last raised in 2005. And since that time, our purchasing power is about 22% down from what it was in 2005. So again, Parks and Wildlife is an enterprise under statute, and so we were asking for the ability to operate like an enterprise and let us work with our customers, really, and stakeholders to figure out the appropriate level of fees. So that bill died, it passed the House, strong bipartisan support in both the House and the Senate, but it died in Senate Finance Committee, largely because the General Assembly had seen fit to backfill an important program that all Coloradans, I think, benefit from, and that's the aquatic nuisance species inspection and decontamination program. That's funded by severance tax. It was looking at significant cuts this year as a result of declines in severance tax revenue. But the General Assembly backfilled it with some general fund this year because it's so important. And then that became a reason for members of the Senate Finance Committee to say, well, we don't need to pass this bill because where's the crisis? What's the big deal? We've taken care of boat inspection stations that, again, keep all of our waterways open to flatwater recreation. Anyway, this was, we had a strong stakeholder group, again, strong bipartisan support in both houses. And, in the words of the former governor of California, we'll be back. And, be working with members in the interim. One bill that we did pass addresses water and trying to remove some of the impediments to getting creative with regard to agricultural water rights. This is the Historic Consumptive Use Modeling Bill. There were some challenges in Division 1, which is the South Platte, and really the bill's been referred to the interim committee. But we're trying to, if the parties can agree to a model for modeling their historic consumptive use, then they don't have to hire a bunch of experts to go to water court. That's sort of the policy behind this bill. And again, it didn't pass, but we were very successful in building strong support, and it was referred to the interim committee. The Rural Sustainability Bill is one that passed. We weren't a big player in that at the department, but this replaces $500 million of the hospital provider fee to rural hospitals, moves the hospital provider fee to an enterprise, allowing some room under the Tabor cap, and gives extra money to rural schools, calls for state agencies to propose budgets that reflect a 2% reduction in spending, and we're still trying to figure out exactly what that's going to look like. And in theory anyway, creates about $2 billion for capital construction and transportation by having a lease back provision for state buildings. Again, this bill came together pretty quickly at the end of the session. We're still trying to figure out how to implement it. But that was a sort of a landmark bill this session. A couple of big items of unfinished business. The $9 billion needed for transportation funding was not addressed. Broadband is another thing that was a priority for the administration that continues to struggle to find funding. And then reauthorization of the Colorado Energy Office. That bill died on the last day in the last hours of the legislative session. And so again, that's something that will likely be addressed, at least in part, through funding over the next year. But those are some big pieces of unfinished business. A couple of federal actions I want to report on. I think I mentioned last month or the month before that the president's budget blueprint was creating some uncertainty in our world. That blueprint talks about reductions or cuts to some federal grant programs that state agencies receive, including divisions within DNR. The Oil and Gas Commission gets $100,000 a year to administer the underground injection control well program from EPA. That's one of the grant programs that was identified for potential reductions. We get money for administering water and other things, and so. Again, there's just some uncertainty about the federal budget. The Interior Department has called for a review of all grants over $100,000. So this is money that's collected by the federal government as an excise tax on hunting and fishing equipment that is then given back out to the states. Colorado Parks and Wildlife gets about $30 million a year in this grant program, and that's about 20% of the funding for fisheries and wildlife programs, staff and operations of CPW. And so there's a lot of angst being created by this and uncertainty about whether we'll be reimbursed for costs that we incur under these grant programs. That again, it's the feds are really a pass-through for this money that's collected as an excise tax. The monuments review, Canyons of the Ancient National Monument, was identified as one of the national monuments to be reviewed at the Interior Department. So we're preparing comments and we'll participate in that process. And then finally, relevant to this this part of the state, just last week there was a secretarial order on reviewing the Greater Sage-Grouse Resource Management Plan amendments, and so we'll be working with the State Office of the BLM once they've identified sort of the team. They have 10 days to identify the leads for that work, and again, this is an important issue here in Rio Blanco County. Some good news on the federal front. May 20th was Colorado's first ever Public Lands Day. This was legislation passed last year in the General Assembly that identified the third Saturday in May as Public Lands Day. I was in Mesa County for that at the Cameo Shooting Sports Complex, and then a big event in downtown Grand Junction. Governor spoke. Everybody was really excited about outdoor recreation and public lands. And then finally, I'd be remiss if I didn't mention the work that's gone into responding to the Firestone incident. Director Lepore and Greg Duranlo are going to, I think, do a report here once we finish with some of the preliminaries on that. But I just wanted to recognize the efforts of Matt and everybody at the COGCC that has been pitching in on this and responding, I think, very responsibly, swiftly, and under some extraordinary and really unusual pressures that the commission isn't accustomed to dealing with, and lots of media scrutiny and public concern, and really hearing those concerns and responding in a way that I think has been very exemplary. So thank you for everything that you've done. And with that, Mr. Chair, I'm happy to take questions on those matters that I covered or on anything else.
Thank you. Any questions for the executive director? Hearing none, we'll continue on with the report from the director.
Thank you, Mr. Chairman. Good morning, everybody. I too want to extend a welcome to Commissioners Boygan and Overturf. Welcome aboard. Pleasure to have you. Look forward to working with you. I think I've known Howard for a number of years through his work with the oil and gas industry and legal work and the Colorado Oil and Gas Association. I've known of Miss Overturf for a long number of years as well. Very, very excellent reputation at the Attorney General's office, and I think we finally met at a Western Resource Advocate celebration several months ago. Very nice to have you on this commission. I guess because we have some new commissioners and because we're in a part of the state that we don't get to often, and it is a lovely part of the state, I would like to take a minute and have the staff from COGCC who are here introduce themselves. There are a number of us. There are some that the commission doesn't get a lot of face time with, so I just thought it'd be worth taking a couple of minutes. So let me start right here. If you'll just tell us your name and what you do and maybe how long you've been with the commission.
My name is Peter Gowan. I am the enforcement supervisor and currently serving as acting hearings manager. I've been with the commission since September 2010. And I think that's probably all I need to say.
Go that way.
My name is David Beckstrom. I'm an enforcement officer with COGCC, and I have been with the commission coming up on 2 years in July. David Beckstrom, enforcement officer, since July 2015.
Stuart Ellsworth, engineering manager, been with the commission 9 years, and it's always been a pleasure to work with the group and work with you.
Yeah, you count. Just go ahead.
My name is Julie Murphy, and I am one of the assistant directors for policy with the Department of Natural Resources, and I'm focused on energy and mineral issues.
I'm Greg Duranlo. I'm the environmental manager, and I've been with the commission since 2010.
Jeremy Farron, enforcement officer. I've been with the commission since 2014.
Carlos Lujan, I'm an environmental protection specialist from the Northwest region of the state, and I've been with the commission for more than 4 years.
I'm Chris Nidell, COGCC Environmental Protection Specialist, the Northwest Moffett, part of Rio Blanco, Rangeley primarily, and Route County and Jackson County.
I'm Alex Fisher, environmental supervisor for the western part of the state, and I've been with the commission since January of 2006.
Alex, good. Yeah, get Enrique in.
I'm Enrique. I'm a production specialist, and I operate all the AV stuff, as you can see. I've been with the commission since 2006.
Hi, I'm Mark Morton. I'm the local government liaison for COGCC. Been in this position for 5 years almost, coming up in about a month. And in addition to that, about 7 years for CDOT prior to COGCC.
Here we have Kent. Kent should
Go get
Okay, good.
Dave Andrews, engineering supervisor based out of Rifle for the west half of the state. I've been with COGCC since 2006.
Stan Spencer, Environmental Protection Northwest Region, based out of Rifle, cover Garfield and Rio Blanco counties. Been with the commission about 3.5 years.
Everybody? Let's get Kent.
I'm Kent Custer. I'm with the Colorado Department of Public Health and Environment, and I serve as the oil and gas liaison, and I work very closely with the commission and try and serve the commission. I've been in this position since 2008.
All right. Thanks, everybody. We have, I guess, keeping that theme, there are some changes coming, well, they're imminent in our personnel. Mr. Gowan, who is noted, has been with us for 7 years in the hearings group, mainly on the enforcement side, is currently the acting hearings manager. It's his second stint as the acting hearings manager. He is going to retire, God bless him, at the end of the month. So, Peter, thank you for your service and for your dedication to the commission and your loyalty. And it'll be sad to see you go.
Thank you. Appreciate it.
Mr. Beckstrom is, I guess we've become a farm club for the AG's office. Train them up, get them going, and then they just walk out the door. It's a great opportunity for David, as it was for Berta Beckstead, who, I know there's something there, Beckstrom, Beckstead, I don't know. Anyway, David will, June 20th? What?
June 20th will be my first day at the AG's office.
Okay. So he's going to the AG's office, where he will continue to work with the commission. So we're pleased about that. And then Kyle Davenport is sitting with the commission today for his first hearing. Kyle has been one of the AGs serving the commission for several years. Yes, most of you will recall that Jake Matter has moved over to Parks and Wildlife, and Kyle is going to fill Jake's shoes and serve the commission as commission's counsel. We're pleased to have him on board. All right, other staff issues of note. Most of the commission will recognize that for about a year and a half, we've been holding vacancies open as we manage our budget in face of the commodity price change and questions from the legislature about whether our staff should be trimmed and our budget should be trimmed. We persuaded, I think, with some good metrics on workload, we persuaded the legislature that despite a downturn in new permits and new drilling and rig count, that doesn't have a major effect on our workload, that our workload is driven more by the number of active wells and the need those wells have to be inspected and the fact that spills still happen and we need to go respond to those spills. So the compromise sort of was that they would keep our funding where it was. We would not backfill vacancies as they arose. And then there's a side debate going on about whether or not the mill levy on production needs to be raised because that is the source of most of our funding. We got to a place where we had about 10 open vacancies. Industry started to feel that, I think, primarily in the length of time it takes to get a permit from us, a Form 2, a drilling permit, or a location permit. We feel it internally in lots of different ways, but we're over that hurdle now. The legislature this past session did authorize a change in our funding in terms of providing an additional $1 million on a go-forward basis out of severance tax. So it doesn't increase our budget, it just changes where that money is coming from, and that severance tax revenue is a little more reliable, a little less volatile, not subject to the commodity price change as much. So we felt that that $1 million a year on a go-forward basis will keep us on the right side of the red-black line, kind of as a projection going forward. They also, in this session, helped us cover the shortfall that those 10 vacancies, kind of the price tag of those 10 vacancies, was about $750,000, and they authorized that funding as well. So we are, with all of that long windup, in the process of backfilling all of those vacancies, and we're moving pretty quickly to do that. Those vacancies are spread more or less equally through different units within the department. So there's a couple of field inspectors, a couple of permitting people, a couple of engineering positions, et cetera, and all of those are in the process of being backfilled. I think, Mr. Chairman, we had very little public comment signed up, but one of the things I did want to make the commission aware of is that public comment sometimes arrives to us through the email inbox and, interesting of late, some postcards. So if you don't mind, I'd like to spend a little bit of my staff or my director's report time to read some of the public comments that we've gotten here recently. And I'll start with, I'm not gonna do this for attribution to anybody. I just want the commissioners to be aware.
Yeah, I think in the interest of the opportunity to hear, listen, and learn, it would be very valuable. So thank you.
Thanks. So there is an ongoing email campaign, I will call it, that really revolves around the Martinez decision and the appeal of the Court of Appeals decision there. I have received about 350 emails related to that. It's a form email. They all essentially say the same thing. And so I'll read you this one. Dear Chairman Matt Lepore, it's nice I got a promotion. Dear Chairman Matt Lepore and other members of the Colorado Oil and Gas Conservation Commission, in the wake of the tragedy at the Martinez home in Firestone that killed 2 men and seriously injured a woman and child, and with more and more Colorado communities being subjected to drilling hazards, including spills, fires, explosions, air toxins, ozone pollution, water contamination, heavy truck traffic, and unhealthy noise levels, it's long past time for your agency to fulfill its obligation under Colorado law to prioritize protection of health, safety, and the environment over its mission to foster oil and gas production. As the commission charged with protecting Colorado's health and safety with regards to oil and gas development, we call on you to take the following actions immediately to restore the public trust. 1, do not appeal the Martinez versus COGCC ruling that the COGCC must prioritize public health, safety, welfare, and environment over oil and gas production to the Colorado Supreme Court and assure that the COGCC fully complies with this legal mandate. 2, order operators to shut down all existing wells until an independent investigator verifies that every well is in full compliance with the recent order to assure the integrity of flow lines from active wells near occupied structures and to cut off flow lines from inactive wells statewide. 3, suspend new COGCC permitting and drilling on existing permits until an independent review of state rules is conducted to assure they are sufficient to protect public health, safety, and the environment. And that's the end of the email. So again, about 350 of these have hit my inbox over the last, I would say, 8 weeks, roughly 8 to 10 weeks, roughly. Although this one must be a little bit newer because it refers to the notice to operators that we issued in the wake of Firestone. And that notice to operators was issued on May 2nd. So I guess there's a little bit tighter time frame around those. Then in addition, these postcards have come. This set happens to be almost all from Broomfield. One of the operators has proposed a fairly large-scale development. I guess large is relative. Their proposal is for roughly 4 separate horizontal multi-well pads, each located about 3/4 of a mile to a mile from the next, running in kind of an east-west direction, essentially along the route of E470 as it passes through Broomfield, which they call the Northeast Parkway, I think, Northwest Parkway. And each of those pads, these numbers keep shifting around as the operator continues to engage with Broomfield, and that engagement has been fascinating and interesting and very robust. But give or take, across those 4 well pads, the operator proposes to put about 140 wells. And that certainly has captured the attention of the residents there as well as the Broomfield City Council. So some of those citizens have sent these postcards. And again, I think I'll just read a few so that you have a flavor of this particular aspect of public opinion. The state legislature failed to change the setback rules further from homes and even schools. Considering Firestone explosion, how can this continue? Wells near homes is an accident waiting to happen. More local control needs to be given back to residents. Health is more important than oil companies' profits. It's common sense not to drill near homes and schools. Please change your stand and change the policies. Dear Mr. Lepore, I was disappointed that the legislature failed to respond to citizen requests to increase setbacks from school property lines to 1,000 feet. The COGCC could also exercise greater leadership to protect against the risk to children and all citizens of current inadequate setbacks. Please consider that you should be a protector of all people's health as well as economic welfare. Do not look primarily after your own personal interests, but the people of Colorado. Dear Mr. Lepore, please don't change our beautiful residential area and let it turn into an industrial zone. Be mindful of your citizens' health and safety. Please keep gas and oil wells farther from homes and schools. Even with guidelines in place, human error can cause catastrophes. Setback requirements need to change. Please stop any more fracking near neighborhoods. Please. So dangerous. Please put safety as #1 concern. Stop the fracking. Human error creates accidents and no one can predict it. Thus, oil and gas and other dangerous industries must be kept at greater distances from homes and schools. Oil and gas companies need to be legally liable. So again, just a flavor. Passions run deep, and lots of recent incidents, I think, certainly can fuel those passions. As Executive Director Randall mentioned, with respect to Firestone, Greg Duranlo and I are going to do a more full-scale briefing and presentation. It's largely is a reprise of the presentation that Greg and I, with support from many other staff, presented to the residents of Oak Meadows, which is the subdivision where the explosion occurred. We did that on May 24th, and we've updated it a little bit based on more recent environmental data that we've acquired. But during this part, I did want to acknowledge the staff effort that Bob alluded to, but that I've seen, kind of up close and personal from our staff. This, needless to say, is a very, very significant event that takes a lot of resources. And as I was in the 2013 floods, just so impressed by staff's willingness to jump in with both feet without hesitation, put in extra time, try to continue to juggle other demands, but to really respond wholeheartedly to this incident. So I want to recognize a few folks by name who have really been instrumental to the agency's response. So kind of starting with the day after the incident, which was the explosion occurred on late in the afternoon of April 17th. COGC staff were on site the following day, April 18th. The staff that were on site that day included Joe McLaren, who was with our Flowline Integrity Group, which is part of the engineering group, Jason Gomez, a field inspector, Mike Leonard, really, who is our Mr. Everything. I can't say enough about Mike Leonard. Mike is within our field inspection group. We call him our quality assurance professional, but he really is our master utility infielder. And Mike arrived on scene Wednesday, April 19th, and immediately began engaging with the Frederick Firestone Fire Protection Department and the police, Firestone Police, as they undertook their investigation of the cause and origin of the fire. And after Mike got there, he saw that the local government officials had a need for somebody with environmental expertise to take some soil vapor samples and some soil gas samples right around the Martinez home, which is that address is 6312 Twilight, that we refer to it often in those terms, and the house next door. And Peter Gintatis from the environmental group responded to that and took some of those very early samples. A lot of the work that has been done has involved the engineering unit, and that has been true in a number of different ways. Obviously, the flow line is involved here, implicated here, and we have a flow line integrity group. And the NTO that we issued on May 2nd is very heavily focused on engineering practices. So within the engineering unit, Stuart Ellsworth, our engineering manager who is here, has done yeoman's work coordinating the efforts of the engineering group. Again, Joe McLaren, part of that flow line integrity group. Mark Schlegenhoff is our flow line integrity supervisor. Elise Hazard is a flow line integrity engineer. And Mike Hickey is one of our engineering. All of those folks have been very, very involved in the Firestone response. COGC's most significant role in many ways in the aftermath of the fire and explosion are responding to the environmental impacts that occurred. So our environmental group has also been very, very busy and engaged. Greg Duranlo, the environmental manager, is here. Greg and I have had some very difficult conversations together in the last few weeks about, how do we do this the best way we can and know, and with all the information, and the information is often seems incomplete and seems to come in and not all there at all the same time as you might like it. John Axelson, our East Environmental Supervisor, Peter Gintatis, I mentioned. Bob Chesson and Stephen Aruza are two of the environmental team that have been out taking samples and trying to help us delineate those environmental impacts. And then Arthur Kepsel is our environmental data analyst, and Arthur has done some great work on some graphics that you'll see here in a little while. One of the teams that's always somehow behind the scenes are our technical services folks, our OIT people, who, especially when it comes to the NTO and what we're trying to accomplish there in a very short period of time with operators inspecting thousands and thousands of wells, and us doing our best to keep track of all of that. The OIT team led by Ken Robertson, who is our senior data analyst, Bryce Holder, who is our data analyst, Chris Eisinger, senior research scientist, and that group's manager, Jane Stanzik, have just been doing a fantastic job. They have created tools, IT data tools from whole cloth, really. They weren't there before. And when they understand what it is that we need and that how we're going to try to keep track of all of this work, they have just created some new tools, and again, pretty amazing. Field inspection group, Margaret Ash is our manager, Mike Leonard, I've already mentioned, and then when the operators, when we got up and running on the NTO and operators were to go out and inspect all of their locations within 1,000 feet of a building unit, we decided that the most efficient way or the effective way that our staff can be involved was to kind of embed an inspector with different operators. And so that's what we've done. So all of the inspectors have spent the last few weeks in the field with these operators as they've gone out to these sites so that they could witness the tests, understand the operations, provide guidance to the operators as needed. And so again, field inspection group has had that role. And last but not least, I also want to acknowledge Bob and the DNR and Julie Murphy and Todd Hartman, our PIO. It's been a pleasure to work with those guys, and again, lots of hard decisions to be made, lots of late nights conferring about those decisions, and pulling together press conferences on very short notice. So really appreciate the opportunity to work with those guys and the entire team. So thanks to all of you. The last thing I want to cover is I'm going to hand off to Stuart Ellsworth, who is going to brief you a little bit on an incident that has been taking place in Debec, which is not far from here, with a methane detection at the surface and a nearby sort of mystery well that may or may not be the source of the methane. So with that little teaser, I'll turn it over to Stuart.
Before we do that, I wonder, can I ask a few questions about what you've already said?
I'm afraid you can, yes.
So I had some questions about the postcards that you received from Broomfield and that development that seems to have sparked those public comments. Is that particular development the form of is it the subject of a pending Form 2 or Form 2A application?
So great question, and the short answer is it is not. And the reason it is not is that the operator, I'll just say the operator is Extraction Oil and Gas. Extraction has been working with the city and county for months now, honestly, in an effort to get really the county permits, or it's a city and county, get those before they file their Form 2A and Form 2s with us. So there's a long history that I won't go into unless you want all of those details. But there is an existing memorandum of understanding between Extraction and the city and county. In part, Extraction stepped into the shoes of a prior operator. They acquired that prior operator's assets. The prior operator had that MOU. Broomfield renegotiated the MOU because their development plan was different than the prior operators. Everybody seemed to be on the same page as far as Extraction's plans, but candidly, when it became clearer to citizens and perhaps the county how many wells Extraction was proposing to put on those well pads, people got a little uncomfortable. And so the city and county then created an oil and gas committee, citizen committee, to review the city and county's comprehensive plan as it relates to oil and gas issues. And Extraction agreed to engage in that process with them. Extraction has concerns about the length of time this will take, mainly because they have concerns. They have leases that will expire at some point in time. So they have a time schedule in their own planning process about by when they really need to have permits in hand. And they've been flexible so far to continue to work with the county and not file those Form 2s and 2As with us. And that's the current posture. They've not filed those 2s or 2As yet. The Oil and Gas Committee, the Broomfield Committee, is committed to completing their work, I want to say early August. And Extraction keeps kind of redoing the math and deciding that, okay, they can, be okay if they, as long as they file their applications by X date. And, we've had conversations with them about what they can expect, a time frame from us. We've told them they should expect it will take 3 to 4 months to get permits from us. But that's still their preferred path. And I'll just, one opinion, unsolicited, historically, operators tended to come to the state and get state permits first and go to the local government and say, see, I have a state permit, so I should get one from you. I think it's a positive evolution that Broomfield is committed to working with the city and county to the extent that they reasonably can to get agreement there before they come to us.
Thank you. That background is super helpful. And one other question just surrounding process is that my understanding is that under the existing rules, there isn't actually a commission action taken with regard to Form 2s or Form 2As, that it is a permit that is granted by staff and there is no commission review over that decision, unless one of the small number of people who are allowed to file a formal protest. Is that accurate?
Close, pretty close. So yes, the director in particular has authority to approve drilling permits and location permits. So at my level, so administratively, it does not need to come in front of the commission for a hearing. Things that come in front of the commission are those that are required by statute and for which there is the hearing opportunity. And that includes anything with a penalty and rulemaking and so forth. There are, by our rules, a identified set of folks who have standing to protest either the issuance or the failure to issue a permit. So, for example, a local government can appeal a decision to issue a permit, and they can compel a hearing in front of you after we issue a permit. If the threshold for consideration is a demonstration that public health, safety, and welfare would not be protected despite our rules and any conditions that we put on that permit. That's sort of the threshold prima facie showing they have to make that appeal. Another way it can get to you is our rules, I think it's rule, not statute, say that if the staff, the director, has not approved an application for a permit to drill or location permit within 75 days after completeness review, then the operator can bring that to hearing in front of you. That has actually happened more times than the other things have happened. And some of those have been because there's so many complications with the permit that staff just is unable to get it reviewed and get on the same page with the operator. That happened recently on the West Slope with development in Battlement Mesa. Or it happens deliberately because I have made a decision that this should come to the commission for hearing. So that's happened a couple of times.
Thank you for that background.
Other questions before we turn to Stuart? Okay.
Thank you, Director. I'm going to speak to you about a situation in DeBeck, Colorado
roughly speaking, near Rifle, if you're not familiar with it. On about May 15th, we became aware of a thermogenic gas presence in a house in Quebec. It was found by Xcel Energy when they were doing a driving survey for gas in the town of Quebec, kind of as a maintenance scenario. They were going around driving, looking for gas leaks in their system and making those repairs. When they investigated this house, it appeared as though the gas was coming from sort of the from inside the house, related to their bathroom, is what I understand, in a crawl space of that. They sampled the gas. It came back as not matching. It did not have mercaptan in it. And so that's when they contacted us and we became engaged. There is, let's see. And in this driving survey, they only found one house in the town or one area where this thermogenic gas was present. They did trace it a little bit to the sanitary sewer system, which was approximately 20 feet deep. And to the north of that, we were aware of an old orphaned well. It was drilled pre-1950s. We have no records of this well. It's in an alleyway in the town. And we call it the Quebec number 8. It was actually drilled as a water well, not an oil and gas well. There are no, one of the things we're looking into is trying to get the records, but to evaluate if there are other water wells in the area. And we're not aware of any historic or present oil and gas wells that were drilled directly in the town, but we're evaluating that. And we've evaluated the gas at this Quebec number 8 well. We've done some sampling. There seems to be a gap. It's about two city blocks away from each other, this house and this well. There seems like a no gas present in that sanitary sewer trench that runs down that alleyway. So gas seems to be present at the house, and there's gas at this old water well. Again, we have begun an abandonment process to plug this well. We drilled on it and we got to 26 feet when we found the bottom of this water well. We can tell we got to the bottom because the tubing they used, it was a driven scenario where they put a point on the end of the tubing and just were kind of driving it into the ground. So we found that, we pulled that out. That was at 26 feet. We continued drilling just to kind of confirm that that was the depth of the well. We drilled to 120 feet. We could tell we were drilling new hole. So we stopped at that point because there was still gas present. We logged the hole using a neutron density log so we could get an electric log, combination log, so we could get the signature of the sands themselves and a signature of gas present. We saw a gas sand at about 30 to 50 feet, so a gas-filled sand present. We did get a sample of that gas, and I should probably stop right there for a second and thank Stan Spencer in the back. He's the environmental specialist that's been out on that site. Craig Berger has been the engineer that's plugging this well. And that's where he is right now. We have cemented off this well from 120 feet up to just above the sand. We used a normal G cement, a 15-pound cement, to plug that part out. Then on top of that, we've placed we call it Halliburton Super. Everybody has it, so to speak, but it's their epoxy cement so that it could seal off any gas. It's an epoxy cement. We've placed that. We're waiting for that to cure, and we'll do a top job, more of this standard G cement, and then we'll cut off the well and we'll abandon it. So that's kind of what's happening there. As far as kind of the environmental review and the gas sampling, we're looking to get that report here soon, but that's where this stands. So if there are any questions.
Commissioner.
Stuart, I have just a couple of questions. So if the gas that's present at the well is at about 30 to 50 feet, but you mentioned that it's not observed anywhere in a path between the well and the house?
That's correct.
So is there a chance that there's just some kind of communication from the gas sand directly into the house?
It's an excellent question, and at this time, I don't have an answer to that question. So I'm not sure. What I can say from a geologic standpoint is you're on what's known as the Debec anticline. So when you think about it, and it's the Wasatch formation that's at the surface. The Wasatch sand is a lenticular sand, so little individual sand bodies that are known to have gas, kind of salty water, and fresh water. So each individual sand can have its own various fluid contents. And so.
Okay, and I guess I'm just trying to imagine how you would evaluate whether there's any connection between the fact that there's an old orphan water well. Is that even pertinent to, is that connected in any way, or do we think it's connected in any way, or are we?
Well, the answer to your question is unfortunately, I don't have a direct answer to that question.
Right.
This is something we need to get an understanding of. And I think we'll try to engage with some of our sister agencies to try to understand that and try to get this in context of the geology, in context of what we do know. And when we get the sort of environmental, we've done several monitor wells and try to get a spatial understanding.
Okay. Thank you.
Mr. Chairman, may I respond just real quickly as well?
Certainly.
I think, Commissioner, we have understood from the beginning of this project that even plugging the well wouldn't be the end of the investigation, that we understand that there may be another source where the well may or may not be the source. So plugging the well won't be the end of where is the methane arriving from.
Yeah, I think we figured that out, and
I'm trying to figure out the microphone.
Commissioner Jolly, if he go first, he's been waiting patiently. Here.
Quick question, is somebody still living in the house?
Oh, yeah, thank you for asking that. We have, there's several points on that. We have put a methane monitor in the house, and there is a positive air system to vent the home. And the answer to the question is yes, the family has chosen to stay in that home. There is a program that is going on through West Slope COGA to purchase methane monitors, and those are being distributed. And they've made I'm not quite sure exactly how it worked, but they made a donation, I believe, to the local fire department or emergency group, and they're distributing and helping install and instruct the local community. And so there's that program going on.
Okay, Commissioner Boykin.
Thank you. That was actually similar to my question. So
Is the gas level in the house the same? Is it reduced? Could you tell whether there was any impact of your activity on the gas in the house, or?
My understanding is as long as the system stays active, that it is removing the methane and getting it below any kind of combustion level.
Which system are you talking about?
The positive airflow system.
Right, okay. But you couldn't tell whether your actions with respect to plugging the water well had any impact on gas continuing to come into the house?
Well, we're still in the process of plugging that well, so we're still doing that plugging job right now. But as of now, no, there's not been a.
Mr. Chairman?
Certainly. Go ahead.
I know you said that the initial leak was found because of a truck roll that found some gas, and then there was some additional testing that happened inside that particular house, and that the truck rolls didn't find anything else at any other locations. But I'm wondering if there's been any testing inside the houses. If there is some seepage through some sort of a sewer, it seems like there might be noticeable levels inside the house that's not necessarily registering through a truck.
I think it might be best, you've now asked an environmental specialist type question. So Alex Fisher, the West Side Environmental Supervisor, has stepped forward.
Thank you so much.
Thank you, Alex. Don't go away.
He knew, he jumped right up.
Yeah, so it's my understanding that Excel did do a survey of 190, 200 homes. And Dave helped me out if they actually went inside the houses.
They did meter measurements in those homes.
Okay, and only one of the residents on Mentor Avenue had explosive levels in the house. West Slope COGA has offered multiple times to put the residents up in a hotel, and they have declined and have elected to stay at the house. With the vacuum extraction system, a temporary system that COGCC had contracted to be installed, with that system operating, the explosive levels have remained 0%, LEL, lower explosive limit. And there has been some incidents before when Excel was operating their system. When their system was turned off, some of the levels did come up in the home. But currently, with the operation of the temporary system that we have installed, the explosive levels have remained 0%.
So sorry, I just want to make sure that I understand. Are you saying that when Excel went and they did a bunch of testing inside the homes, and when they turned off their system and then turned it back on, that the levels inside the houses went up? But I thought we thought it wasn't Excel's problem.
So it appears that it's not Excel's problem. Excel found the issue. They had constructed a trench, put in a vacuum extraction system in the trench that was evacuating the explosive vapors, the methane, from this trench directly behind the house. When that system was shut down is when some of the explosive levels came up. And so Excel has since backfilled their trench, and we have put in a temporary system, not only in the crawl space, but within their trench.
Commissioner Egger.
What system have you put in?
It's just a temporary vacuum extraction system.
Vacuum extraction. And then I think Mr. Ellsworth said that it was thermogenic gas. How do you know? Was it thermogenic gas in the house or thermogenic gas in the water well that you plugged?
We, COGCC had contracted out a soil gas survey. We do anticipate results yet this week. And I believe that those thermogenic readings were based upon some of the samples that Excel took.
So those are gas, not water?
Correct.
Gas in the house. or in their soil vapor extraction?
This was, I believe, out of their soil vapor extraction trench.
Yeah. And where does the house, where do they get water? What's their water source?
I believe it's a municipal water supply. Yeah.
And I'm just clear that the well that is plugged is just, it's a water well, not a production well. It was never a production well?
Correct.
Right. Okay, thanks.
I think we're there.
One more.
May I say it's certainly a good thing that we came to Meeker today.
Again, Dave Andrews, engineering supervisor at a Rifle. So up until my vacation last week, I had been working with the town, the county, fire department, sheriff's office, Excel. We had been having daily calls, and we continue to have daily calls during the week. The only detection in a home was at the subject residence where the vacuum extraction system is working. Of the other 180 to 200 homes that Excel monitored with handheld meters, there were no detections at any other homes in the town. With the soil gas survey, the well is about 1.5 blocks north of the residence. So we had some soil gas detections around the well. When we pulled the surface casing out, it was only about 10 to 12 feet deep for drilling the water well. So there were some methane detections in the well itself before we pulled the casing off. But that is isolated from the detections that we were seeing in the residence. We collected many soil vapor points along the sewer line in the alley because initially we thought, there's some potential for that to be a conduit for the migration. And at least as of right now, it appears that those are isolated instances. As far as the thermogenic gas, so far I haven't seen any thermogenic results, and we're waiting on laboratory analysis for that. The initial observations were based solely on composition. So both Excel and Williams, who also has a high pressure pipeline in the right-of-way along the railroad track south of the town, collected samples from their pipelines and also from the well and from the trench behind the residence. So just based on composition, the characteristics of the gas in the well and the trench appeared to be different than the characteristics of the gas in the pipelines, in addition to the lack of mercaptan that was evident in the Excel pipeline. So, we're waiting on the isotopic analyses to verify that. And then also we collected samples from 5 other oil and gas wells in the vicinity of Debec within about 3 miles. So the goal is to compare composition and isotopic analyses, and the well that's being plugged, samples collected from the trench behind the house and then surrounding wells to get a better idea of, geologically, is this more widespread or is it isolated to, these 2 pockets, so to speak, right now.
And those surrounding wells that we've collected samples from are orphaned wells, are not active wells.
That's correct. The nearest industry-operated well, I think it was on the order of 3 to 4 miles away.
And no old plug and abandoned wells in the vicinity?
Those 5 wells that we collected samples from, those are orphan wells. We have been plugging orphan wells in the Debec area for about the last 6 years or so. This field was originally drilled around 1900 and 1905. So, we still have some work to do around the town. But other than the subject well that's being plugged, there's one well near the northern boundary of the town. It's kind of off in a pasture. That one does have a wellhead on it, but there are other wells in the outlying area that are more rural that we're scheduling into our orphan program, which I'll talk about a little bit later.
Yeah, so if Excel was conducting these surveys anyway and put in a mitigation system, is that common for them to find this in this area and address it?
As far as I know, that's the only time I'm aware of in Quebec where that has occurred. So as they were doing their surveys, there were, as I understand it, a few other meter leaks that were repaired. But other than that, it was just this residence and the well a block and a half to the
And I
north.
guess I just have a general question. If it's a water well and not a production well that we plugged, and you're sampling the orphaned wells, if it turns out that there's nothing in the fingerprinting that associates production with that gas, is our role over?
It depends in a way, as Mr. Ellsworth pointed out, the whole town is on top of the Quebec anticline and Mesa Verde formations at roughly about 700 feet below the town, with Wasatch overlying Mesa Verde, which does have stray gas and sandstones and alluvium from Roan Creek and the Colorado River overlies the Wasatch Formation. So, it's a little bit complex based on layering and also structure for the geology.
So is COGCC responsible for stray gas?
Well, at this point, we're involved. Yeah, we're involved because of the well plugging and the environmental investigation. Then beyond that, Matt, would you like to chime in?
I think you guys were doing great. Keep going. It's a really good question, and I think the conversation will turn to engage local officials and probably the Colorado Geologic Society. So there is the capability to identify a geologic hazard, and Stuart can probably talk about that better than I can. But there is a point at which our role should end, but we don't want to walk away prematurely. Make sure that public health is being protected and get the right people engaged in that conversation to reach that end.
I will add that, plugging a well that has gas in it is and orphaned wells does fall into so in part, that's why we're taking the forward step and plugging this well, because that's within our staff skill set. And as you can hear from both Dave and Alex, they're very knowledgeable. I was giving the brief review and you got a lot more detail on that. And so I think that's where our role is, and we need to not let the ball drop on this, but we need to kind of keep awareness.
Yeah, and I totally agree, and I'm not suggesting otherwise. I appreciate
you
guys taking the efforts that we have so far.
Yeah, I think I did hear the director comment was that our role won't end with the plugging of this well. They're going to continue to run other possibilities to ground with this. And I think involving the Colorado Geologic Society and the local community is great, because this, and this extends sort of outside the city also. So I guess my question would be, with respect to some of the methane monitoring, is there a possibility that may be expanded? And would that be something that we would get involved in also? Is that still going to be looking more to Western Slope COGA to help with that, with some of the homes and smaller communities in the area?
I think we'll take that as a suggestion, and as we go forward, we'll try to dive into all those different avenues you're suggesting.
Okay, thank you. With that, Director, have we concluded with the report from the director?
With one addendum, if I may, Mr. Chairman, one of the other aspects of Firestone that I neglected to mention previously is I don't even know anymore how many times we've been CORA'd. I think that's a verb. Colorado Open Records Act requests, multiple requests, and Kyle Davenport from the AG's office has been the point of that spear. So thanks to Kyle for his work on that aspect of the case, which is, I kind of do this and say, just go do whatever you have to do. So thanks.
Okay. Thanks to Stuart and the other two gentlemen, Alex and Dave. Thank you, Dave, for stepping forward and providing a lot of clarity around this. Very much appreciated. So with that, I believe we have an opportunity for commissioner comments. Hearing none, let's move on. I think we do have some audience comments, I believe.
Yes, we have one sign up, and that would be David Ludlam.
Good morning, Mr. Chairman, members of the commission. My name is David Ludlam. I'm from Grand Junction. I represent the West Slope, Colorado Oil and Gas Association. About 2 months ago, the co-chairs of our local operators task force committee sent a thank you letter to Director Lepore, which I'm not certain, but I presume is probably the first time he's ever gotten a thank you letter for those on the front lines of regulatory compliance. But the reason that he received that thank you letter was our operators task force committee has been meeting for about 6 years. And for the first 2 years, we would meet with our local LGDs and maybe the county road and bridge department, maybe Mr. Massey here. We go through our local issues, and then we spend the next 2 hours complaining about the state issues. And at one point in time, we decided to pivot and actually try to be a little bit more constructive and proactive. And so we asked Director Lepore if he'd be willing to come at least once a quarter and meet with our operators task force to get that field level perspective on how implementation is going, but also provide us with feedback on what we need to be doing better. And I can say that the director's office has not missed a meeting in 4 years. And that has allowed us to make some significant strides, I think, in improving and enhancing our compliance. And I think it extends over to the pride we have in the efforts our peons operators put into complying with the NTO. It would have been easy, I think, for our producers to say, we're over here where it's rural, and why are we having to do all this? And there wasn't any of that. I think everybody saw the importance of this and rose to the occasion, so we were proud of that. The other thing I wanted to bring to your attention, so I wanted to first thank Director Lepore and his team for those communicative efforts on the ground, which by extension also I wanted to thank you for being here, because I think it's within the same spirit that you're here in Meeker today. It's not easy from a time standpoint, but important from a communications standpoint. The second thing was the issue in Quebec. As was referenced earlier, our association has stepped forward and provided methane monitors to any resident in Quebec who wants one. And I believe that we're up to 120 that have been distributed. And it would be easy to say that that's a West Slope COGA initiative, but I want to spell out the actual companies who are supporting that, because they don't have operations in Quebec, and I think they deserve to be recognized. It would be Chevron, Caris Oil and Gas, and Laramie Energy. And their response to, where is the gas coming from? Why should we be providing monitors? We're not there yet. It doesn't matter. As was referenced earlier, I don't know if it's too much to call it a geologic anomaly, but because of the formation there, we think it makes sense for people to have monitors no matter what, even if there wasn't any oil and gas drilling in the area. And so we're going to continue that program, and we've made it known through the fire department there that we will provide those monitors to any Quebec resident who wants one moving forward. I can also tell you these residents truly love their home, because I do want to correct staff on one thing. We didn't offer to put them up in a hotel. We offered to put them up at the High Lonesome Ranch just up the road, and they declined. So they truly love their home. I'm glad that COGCC is doing all they can to protect it. In relation to the question that was brought up earlier about what could we do as an association moving forward, I think we've had some discussions about, and maybe we could get some guidance from you all on if it would be good for us to do some public education about what that geologic anomaly is and what it means if you live in Quebec, and why it might make sense to have monitors in your home. So thank you for being here. Thank you for staff for the Operators Task Force Committee efforts. It's a great help to our basin. And does anyone have any questions about our role in the Quebec situation?
Yes, Commissioner Walt.
Thank you, Mr. Chair. Thank you. A question for you, from your perspective, when you're providing the monitors, if folks have a positive monitor, where should they call? Who should they call? Or what are you providing then as far as follow-up, if anything?
Right. So through the Operators Task Force Committee, we often work with local special taxing districts and counties. And so we have a really good relationship with the Fire Protection District. And they are the distributor of these monitors, and they're also the communication medium for letting residents know that they're available. So we put together a flyer, and that flyer was distributed to every household in Quebec, letting them know this is available. We'll probably do that on an ongoing basis, programmatically, probably in the ensuing years. So there's a vehicle for people being aware that they're available.
Just a comment.
Yes, go ahead.
I think it's great what you guys are doing. And then I come from La Plata County where we have a lot of stray gas that enters into residential homes. And I can say that if you're thinking about putting together some information, I would encourage it. And you might reach out to the La Plata Energy Council, which has done something similar in our area for local homeowners.
Well, thank you for the lead, and I'll certainly reach out to Ms. Zeller on that. Thank you.
Very good. Any
Thank you,
other?
Mr. Chairman.
Thank you. Any other questions or comments before you escape?
I think that covers it.
All right, thank you.
So that's it for people who have signed up to comment.
Okay, I'll offer one more time, anyone who didn't sign up that would like, because we had a few folks come in after we started that would like to have a comment. Okay, well, with that then, we can move on to the consent agenda. Starting with that, we have consent agenda items A through T. I should ask initially if there is any one of these that are potential conflicts for any of the commissioners that need to be excluded.
Mr. Chairman?
Yes.
Several of the items on the consent agenda involve extraction oil and gas, a company that I have done legal work for. I'm not currently doing anything for them, and I don't do commission work for extraction. I think I can be impartial in my consideration of these items, but if commissioners think that I ought to disqualify myself, recuse myself from consideration, I'm happy to do that.
I would ask the commissioners, it sounds like that it would not be a conflict for Commissioner Boygan, but I would ask the commissioners, anyone have any concerns about Commissioner Boygan voting on extractions items within the consent agenda? Seeing none, they will, perhaps a motion might be appropriate at this time.
I move approval of the consent agenda. Items group items A through T.
We wait patiently for a second.
Second.
Also moved and seconded. Any discussion? If not, all in favor, please signify by saying aye.
Aye.
Those opposed, same sign. Consent agenda has been approved. We have next on the item list is the consent enforcement agenda. And I think there may be some commissioner comments, may want to have some comments before we entertain a motion on the enforcement group A. So is there any commissioner comments on that?
Yes, Mr. Chair.
Thank you. Commissioner Overturf.
I wanted to just make a brief comment about the first item that's on the enforcement group consent agenda. It's docket number 1705000003. And while I will vote to approve the AOC in this proceeding, I did want to make a qualifying statement that I do believe after reviewing the record that this case presents a pattern of violations, but I do also recognize that Rule 523D3 states that a pattern of violations can only be established by prior commission order in the form of an AOC or an OFV. Having reviewed the rule, I can't help but conclude that the rule unnecessarily limits our authority as a commission, likely constrains our enforcement staff, and fails to incentivize voluntary operator compliance. And so while I acknowledge that this AOC is consistent with the existing rules, I do sincerely question the policy wisdom of Rule 523D3. And I look forward to better understanding the history and rationale behind this rule in conversations with staff and commission counsel going forward. Thank you very much.
Okay, I think that's very good comment and appreciate it. So with that,
Mr. Chairman?
Yes.
So do you want to take comments on all the enforcement items?
Certainly.
Or one at a time, or what?
If there's any other normally if there are other comments on any of the enforcement items, let's take them now.
Okay, so I do have a few comments. On the Chevron item, docket number 17050024, several things struck me. One is the AOC imposes separate violations for the same act under different rules. In other words, because of the overlap of commission rules, the same act can violate any number of rules, and by the commission's practice, by staff's practice, which I've seen over the years, each violation of a separate rule for the same act constitutes a separate violation. I'd like, and it doesn't have to necessarily be today, but I'd like staff to comment on that, because to me, it has always seemed problematic to penalize the same act under a variety of different rules and effectively accumulate or aggregate penalties for what is really only a single act. So I'd appreciate some comment on that at some point. It doesn't necessarily have to be today. The other comments I have on that proceeding are, I'm not sure how you determine what's a moderate impact. I'm not clear on how you determined the violation days were 2, when apparently it took 2 days to discover the spill and commence cleanup, but apparently there was some continuing impact for a while, including some elevated salt concentrations. So I'm wondering how the 2 days were determined. And so those are my comments on the Chevron proceeding. On the other 2 proceedings, I'm troubled, which are both essentially orphaned well type proceedings. I'm troubled by the longstanding pattern of misconduct, ignoring the commission, inability to carry out, to comply with commission rules, inability to demonstrate financial responsibility, and then at the end of the day, what we do is we go in and we plug the well and we bar them from operating in Colorado, which is fine, but how does it get to that point? Number one, how do we know that this party, in fact, is financially unable to discharge its responsibilities? Do we ever pursue civil litigation or some kind of investigation to see whether they can respond? And do we know whether there are other owners of interest in the well who might be able to step up? Thank you. And I noticed that there's going to be a presentation later on orphaned and distressed operator program, so perhaps you were intending to get into some of this.
A multiple part comment. So I think, should we start with Mr. Beckstrom or Mr. Lepore?
If I may, Mr. Chairman.
Certainly.
I think very interesting points raised by both commissioners. I think David can provide some details on the Chevron case in particular. The others raise pretty significant policy questions, resource questions, practice questions that I think are perfectly appropriate for a conversation at some point. I don't know that today now is the right moment for that. I will say that, and I first should say that I am not familiar with the details of the last 2 cases here. But the question of longstanding lack of compliance or claimed inability to comply and operators that don't have a lot of financial resources are things that we struggle with a lot, that we have struggled with for a long time, that I think we've been more aggressive about in recent times than in years past. But those are things that you will see. This won't be the only time that you'll see those things, and we should talk about some of those policies. To the best of my knowledge, we have never pursued civil litigation as a means to kind of another avenue to pursue. There is a provision in the statute that allows it under certain circumstances. And the other owners of interest is another good topic for discussion that we haven't generally pursued. Days of violation, I don't know if David may have something on that specific to Chevron. I think beyond that, it's a challenge in a lot of factual circumstances, and I'll let him speak to those in this particular case. And the moderate impact part, I'll just say that in our enforcement policy, which is a written policy, we do talk about, we've taken all of our rules and assigned them a category 1 through 3, and that's the starting point. And then there's a penalty matrix. So the penalty matrix is always the starting point. We have discretion to vary from that, but we hear to it pretty closely most of the time.
Thank you, Director Lepore. My name is David Beckstrom. I'm an enforcement officer with the Commission. I will do my best to answer your questions, Commissioner Boygan, regarding the Chevron case. I will say that case was negotiated with Chevron's counsel, Scott Campbell, who was unable to attend the hearing today, but was going to try to listen in remotely. So there's a message to Scott if he is listening remotely. Scott, I sent you the conference call-in number. Feel free to chime in if you would like to comment. He did want the opportunity to address any questions that might come up as well, but again, could not travel to the hearing. So with that being said, this case was very interesting. So the issues arose at Chevron's Rangeley Field, which is, I've heard staff describe it on numerous occasions as probably the most complex field in the state, and one of the more complex fields in the nation. This field consists of a number of wells using what they call water alternating gas secondary recovery. So they are using both water and gas to control pressure within the reservoir to produce the producing wells. So to accomplish that, there are approximately 400 miles of flow lines in this field that carry everything from oil, gas, produced water, as well as I believe they use carbon dioxide for injection. The issue at this well arose under unique circumstances in a unique field. There was a significant rain event in which approximately 1.5 inches, I believe, of rain fell in the course of 24 hours, along with severe lightning. And the well that produced to the line that failed actually got the tower, the communication tower associated with it got struck by lightning. So the monitoring systems that fed back to Chevron's main hub were effectively disabled. In this field, they have what they call siphons, which gather stormwater primarily is what they're really designed for, but they also, in effect, will collect any oil that is released in an event like what happened on August 8th. So there are 43 of those siphons in this field. On August 8th, during that rain event, all 43 siphons filled to capacity, triggering the alarms that they have associated with those siphons. As a result of that, Chevron was left trying to figure out how to respond to all of the things that were happening simultaneously in the field with imperfect information because of the communications towers that had been affected by the lightning storm. After that event, they walked every piece of line and every siphon, and it took 2 days to discover this release. The reason that staff and Chevron, to be honest, because this is a negotiated AOC, really honed in on that failed check valve as the cause of the violations themselves, is that had everything worked appropriately, the spill would have been fairly de minimis. Chevron would have discovered it in a timely fashion and responded accordingly. Because of that failed check valve, fluids continued to backflow and the spill continued for 2 days. And that was really where staff determined that that was the source of the real root cause of the violation. So here we focused on 3 different rules. 605 specifically relates to the failure of that check valve. That is a rule that basically says everything has to be maintained in mechanical working condition. Check valve that fails obviously fails that test. 907 relates to more of the impacts from that failed valve. So those impacts were contained within that siphon system and did not make it to waters of the state, which is why we did not allege a more severe pollution type violation. But they did continue to release, but again, were contained in that siphon system. And then finally, 1102 addresses sort of keeping all of those flow lines in working condition. And of course, any failure of a flow line is, I would say, evidence of a lack of working condition. In this instance, the line failed itself, but the continued spill really related to the failed check valve. So the reason that we looked and focused on, that might have been Scott Campbell joining us. That was what that noise was. And the volume on this is up. Scott, chime in if you would like. So that's what we really focused on, was that root cause of all of the issues. And then again, this was a negotiated agreement to come to a resolution with Chevron. In light of all of the complicated factors, we felt that the penalty was appropriate. And again, the 2-day violation stopped when they commenced corrective actions as are required by Rule 523. So even though there were ongoing impacts and those are still being remediated, they commenced the corrective action when they discovered it, and they brought a remediation team out to start dealing with the same soils that were in the siphon and the fiberglass line that ended up actually being broken by the undercut goalie, which was really the failure that was exacerbated by the failed check valve. So with regards to how we determined this was moderate, we looked at the fact that the violation did cause the release of about 13 barrels. I apologize, I'd have to refresh myself. 29 barrels of oil and 229 barrels of produced water. And that mixed with 3,000 barrels of stormwater. So again, we felt that there was an impact to the environment, but because it was contained in that siphon system, it didn't get to that point of being a major impact. So that was how we ended up with 3 violations as moderates for 2 days. I think that answers the questions you posed. If there's anything else that's come up, I would gladly address that as well.
Thank you. That was very helpful. I'm fine with approving the AOC. I would like a discussion at some point about this concept of aggregating violations under different rules for the same act. I do have a concern about that long term.
And Mr. Chairman, if I may, I'll address
Yes.
that on a more generic basis. I think, Commissioner, that prior to the statutory change that increased our penalty authority from $1,000 per day to $15,000 per day, and I was the Assistant Attorney General for a couple of years in that time period, sort of that, I'll call it double dipping a little bit, was often the only way to find a penalty that seemed to fit the violation. So there were instances historically where the same act would get you dinged under very similar rules. I think subsequent to that statutory increase, we've tried to avoid doing that far more than we did historically. And so the same act can, in fact, clearly violate more than one rule. We try much harder to make sure there's a different element to each violation that we feel has been breached before we do that. When they overlap, if it's a Venn diagram and the overlap's 80 or 90%, I think more often than not now only pursue one of those. So I think there's a bit of a change historically, and we are very mindful of that, of what you say. It is a fact within the rules that things can have a lot of the same elements.
Thank you.
And I will add on to that just very quickly. Staff may have pursued this somewhat differently had this not been an administrative order by consent that had been agreed upon by opposing parties' counsel. If this went to contested hearing, I think it would have looked a little different in the end. So I think that was a large portion of why we had the result that we did.
Appreciate the clarification, because like Commissioner Boygan, when I read this, it seemed like an awful lot of overlap. So I appreciate some clarification on that. I had a question about, I apologize for asking a question, but the last two are both domestic well issues. Do we know how many other domestic wells, ballpark,
are out there. Because this is going to be, I think, going to be a growing concern. Because every one of these, typically they're a well that was drilled by some company and then handed off to the local resident to run their furnace. And then when it comes time to abandon the well, they just say, essentially just give it over to the state. And then the state is stuck with this.
That's a fair characterization. I don't have good numbers on that. I think Stuart Ellsworth, engineering manager, might have a better guess as to how many domestic wells we're talking about.
I don't have a discrete answer for you right now. I can get it. I can look it up. I got to jump on the web and look it up. Just to give a gross characterization of what we know and in our system, a couple dozen-ish kind of thing. I can get you a more specific number.
I mean, that's not material. Then if it was 300 or 400, that would be something to be concerned about. But 15 to 30, that's a little bit less of an issue, but still a concern.
Right.
Yeah. Okay. Thank you. Any other? Yes.
I had the same question, and to follow up on that, is that amount of financial assurance pretty typical for those domestic wells?
Most of the domestic wells are old, historic, and so the financial assurance is very limited. What I'd like to say is make sure, since I'm broadcasting here, everybody who has a domestic well is subjected to or needs to be regulatory compliant to all our rules. The only rule that they do not have to comply with is reporting the production.
Right.
So that's when a few folks come to us and discuss their well, or during these enforcement things, that's one of the things we point out to them, that they need to be regulatory compliant. And that's when they tend to want to forfeit this well.
And in the case of these two matters before you today, the financial assurance that was posted was that which was required at the time that they took ownership of the well. And obviously we have no mechanism for increasing the financial assurance. That's a statutory issue.
Is this a practice that's allowed today to convert a well to domestic purposes?
I think it's fair to say we discourage it to the extent possible. And once we explain to the domestic operator that they are obligated to comply with all rules, they decide they don't want to do that, and they basically surrender the well, as was the case in these two instances.
I think today, if it was to transfer, then they would be subject to the current bonding requirements, which are significantly higher than this assurance.
Right.
So that may help forestall some of that happening as far as future domestic wells.
Okay, thank you.
Thank you, Stuart.
Commissioners, I just wanted to let you know, this is Scott Campbell. I am on the line. I apologize if I was a little bit late in calling in. There's a lag on the streaming. So I got on the line maybe midway through David's explanation. Don't think we disagree with anything David explained to you, but I just wanted to let you know I am here if you do have some follow-up questions.
Any follow-up questions for Mr. Campbell? Okay.
Thank you, Scott.
I think that I would have to say we've probably spent more time on that than we have on most consent enforcement groups, which was all valuable. And I appreciate that and appreciate the new commissioner's comments and other commissioners as well. So with that, I think if we're finished with comments, we'll entertain a motion.
I move approval.
Okay.
Second.
Been moved and seconded. Any discussion? If not, all in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries. Okay. We have on the agenda a Firestone update, but Mr. Gowan, with your approval, perhaps it would be a good time to take a quick break and then take the Firestone update after the break.
That would be fine, whatever the commission desires.
Okay, is that
You don't need my approval.
Okay, so we will take a brief 10-minute break and reconvene.
frame it in terms of what happened in what order. So as I mentioned earlier, and the explosion occurred at about 4:45 in the afternoon on Monday, April 17th. The explosion killed 2 persons, Mr. Martinez and Mr. Irwin, who were in the basement of the home doing some work. The explosion and fire severely injured Mrs. Martinez, who was upstairs, as we understand it, and was trapped in the home underneath burning rubble. The Martinezes have 2 children, an 11-year-old and a 9-year-old. The 9-year-old girl was out of the house at the time and was unharmed. The 11-year-old boy, as we understand it, was in the upstairs of the house, literally was blown out of the house and suffered minor scrapes and bruises. Mr. Martinez and Mr. Irwin are brothers-in-law. Mr. Irwin is Mrs. Martinez's brother. So lives were lost and lives were changed forever on that day. COGC staff responded on April 18th. Again, I mentioned this briefly earlier. We had a field inspector on site. We had an engineer on site. Initial reports early on the 18th were that the explosion was caused by the gentleman in the basement replacing a water heater. And those reports were pretty strong through the better part of the day Tuesday, that we heard that the fire department had made a determination that the water heater was the cause. By late Tuesday, that had come into question, and conversations had begun to be raised, questions had begun to be raised about a well, an oil and gas well that is 180 feet from the back fence of that home at 6312 Twilight Avenue. That was an active vertical well that presently is under the ownership and operatorship of Anadarko. By April 19th, communication was that there was a 1-inch poly return line associated with that well that was connected at that well and for which the terminus was uncertain. And about that same time frame, April 19th or 20th, efforts began to trace that line. The line was identified as running coextensively with a metal 2-inch flow lines, which were found using magnetometers, and then excavated. So using a water knife to excavate those. And the poly line could be seen following those metal lines. The terminus of that line was.
Boy, I tell you, I'd love to wake up and.
Local government investigators. Peter Gontadas had been on site, as I mentioned, to collect oil and gas samples and soil vapor samples. Those samples showed very high concentrations of methane in soil, both at the 6312 and at the immediately adjacent house to the west, 6310. And 6310 residents did not return to their home and still have not returned to their home, just to give you some sense of what's going on. Their home sustained slight damage from the fire and explosion, but they have been out of the home because of the continuing presence of methane in the soil in their, on their property. So that kind of was the state of affairs as we got into that first weekend. Early in that week, Anadarko indicated that they intended to shut in 3,000 domestic wells in the DJ Basin. Sorry, not domestic wells, oil and gas wells that are their older vertical wells. And they made that statement publicly on April 26th. At that point, the Frederick Firestone Fire Protection District had not made a cause and origin determination. They were still, their investigation was ongoing, but this was, I don't know if you say a proactive or perhaps preemptive statement or action that Anadarko elected to take. We had been in communication with Anadarko for about a day prior to that on this issue, so we weren't caught by surprise by their announcement. And in fact, COGCC issued a press statement that same afternoon, right after Anadarko's statement was issued. I think I will read that COGC statement to you just again to, try to give you the full flavor of this. This went out fairly late in the afternoon of the 26th. The Colorado Oil and Gas Conservation Commission is assisting the Frederick Firestone Fire Protection District and the Firestone Police Department with an ongoing investigation into the fatal home explosion on Twilight Avenue in Firestone on April 17th. COGCC has been engaged in the investigation since Tuesday, April 18th. The COGCC's role in the investigation has been to ensure the protection of public safety and the environment. COGCC is directing environmental sampling and inspecting oil and gas wells in the vicinity, including an Anadarko oil and gas operation located approximately 170 feet southeast of the property, and reviewing the well's history. COGCC is also evaluating additional steps to review activities in the region. COGCC will continue to work with all parties and apply all necessary resources to assist in determining the circumstances associated with this tragedy. And I think that is a fairly good summary of where we were at that moment in time. We held then a press conference on April 27th, which was invited the press over to the Wasatch hearing room at COGCC, and just elaborated on some of the details of what we had been doing up to that point in time and kind of what the plans were for going forward. Also on April 27th, the environmental group initiated some grid sampling, soil vapor sampling. So very deliberate grid outline going east and west from 6312 that covered the homes along Twilight Avenue, front yards and backyards on both sides of the street. So you'll see a map here in a minute. It'll make it easier, but Twilight is the southernmost street in this subdivision. So houses to the south, on the south side of Twilight, back up into open, undeveloped space. Their front yards face the street, and then across the street you've got front yards from those other homes. So we initiated that grid sampling on April 27th. On May 2nd, the Frederick Firestone Fire Protection District announced its cause and origin determination and held a press conference announcing the same. I will read you an excerpt from that May 2nd Frederick Firestone Fire Protection District press release. Since April 17th, investigators have been on scene diligently working with assisting agencies to piece together what caused this explosion. It has also been a top priority to ensure the safety of the surrounding area and residents through site and area monitoring and testing. Investigators have reached the conclusion that the origin and cause of the explosion and subsequent fire that destroyed the Martinez home and damaged the neighboring home, resulting in the deaths of Mark Martinez and Joey Irwin and the severe injury to Aaron Martinez, was unrefined, non-odorized gas that entered the home through a French drain and sump pit due to a cut abandoned gas flow line attached to an oil and gas well in the vicinity that, while abandoned, had not been disconnected from the wellhead and capped. Officials have also determined that the flow line was controlled with the shut-in or ceasing of production of the well as a precaution taken on April 17th as part of initial response measures, and that no additional contamination or danger exists to neighboring homes. Again, we had been in communication with Frederick Firestone Fire Protection District. We knew this announcement was coming, and we also were prepared we ended up holding a second press conference that same afternoon to talk further about, what we also understood and how this would affect what happened going forward. On May 3rd, there was a governor's press availability that Mr. Randall and I, we stood by. We didn't actually, the governor handled it all, and we were there just in case. And on May 2nd, we issued our notice to operators. That is this document that is posted on the website. And I'll talk about that a little bit more with the actual presentation. But suffice it to say that May 2nd was a busy day, but that I do feel that that staff working with the executive director's office, I think we were pretty well prepared. Again, knowing kind of the stage of the investigation that Frederick Firestone Fire Protection District was, having worked closely with Stuart and the engineering group up to this point, based on our understanding of the circumstances, to get this notice to operators prepared, which does, in our mind, get to the most significant causal aspects of this, and also for sort of from a preventative point of view going forward, what needs to be done, what do operators need to do to absolutely minimize the opportunity, the risk, the possibility that anything like this happens again. So I'll talk about those details in a second. On May 5th, we met with the operators to talk about this notice to operators about what was being required of them. It was a very productive meeting. It was clear, I think, that operators were very willing to engage in this process, felt that what we were asking was appropriate, and lots of assurances that they would bring the resources necessary to bear to get that work done. Later on May 5th, which happened to be a Friday, and I used to look forward to Fridays because it was the end of the week. Now I have a slight dread of Fridays because somehow there's some Murphy's Law that bad stuff happens Friday afternoon at 3 o'clock. In this case, what happened Friday afternoon at about 2:30 was that we got the first soil vapor samples back from one possible other anomalous spot that an earlier survey had detected. And that spot is along Oak Meadows Boulevard. We'll show you a map. Oak Meadows is sort of the west side of this neighborhood. And there was a part of this same flow line, there was a T connection in this flow line. So part of it went to the north, and that's the part that was terminated next to the house. But there was a T that went west. And we discovered that that T terminated under Oak Meadows Boulevard, and there was a very concentrated area of methane there as well, we discovered Friday afternoon. The good news is that we immediately sampled just south of the residential homes along Twilight there, as close to those homes as we could be without getting into their backyards. And those soil vapor samples came back at just a tick or two above background. So they weren't zero. Background's not quite zero. They were just a tiny bit above background. And we communicated all of that to Frederick Firestone Fire Protection District, talked amongst ourselves, and determined that they were so low that it was an indication that the methane that existed a couple of 100 feet to the south was not migrating and was not expanding as near as we could tell. So, but it was a challenging day to learn all of that and to make those decisions. And you'll see the data that has resulted now in the subsequent investigation that has occurred. On May 7th, so now this is a Sunday, the National Transportation Safety Board commenced their investigation. They had made the decision to investigate on May 5th. On May 7th, their investigator-in-chief arrived in Firestone and went to the site and commenced conversations with the Frederick Firestone Fire Protection District. On Monday, May 8th, the NTSB held their first meeting with what are called participating parties and began their factual investigation, including some witness interviews. COGCC became a participating party on May 10th, and we began participating in those witness investigations, I think that same day. And then I'm going to fast forward a little bit to May 24th, which was the date that, as I said earlier, Greg and I and some other staff went to, made a presentation to the neighbors in Oak Meadows. We had actually contacted the Homeowners Association on May 3rd, the day after the cause and origin announcement, offering to meet with them, and they proposed this date of May 24th to us. That was a scheduled meeting they already had on their calendar. They were meeting with Anadarko that day and asked that we come and be a presenter at that meeting as well. And so that is how that came to pass. So that, I hope, helps you understand sort of, again, kind of sequence of events for the first few weeks in the immediate aftermath of the explosion. I believe that I circulated to the commissioners a copy of the comments, the prepared comments that I made at the April 27th, the first press conference. I have those and would be happy to share them with you if you don't have them, or if I think I did that previously. On May 2nd, when we announced, May 2nd was the cause and origin announcement, our announcement of the NTO, and the governor's office also issued a statement that day, which generally has been characterized as the governor's order, and so that's just fine with us. So we have a governor's order motivating the operators as well as our NTO. I will say that the NTSB investigation has been an interesting wrinkle to things, mostly because the agreement to become a participating party includes a provision under the Code of Federal Regulations, Part 89, subsection 831.13, about dissemination of information. And the NTSB takes a broad view of what is part of the investigation. So for a couple of weeks, we have been working under the understanding that all of the environmental investigation, all of the environmental data that we have been gathering and working on falls within the ambit of that investigation, and therefore, before communicating it to the public, we need the NTSB's approval. That proves cumbersome and, frankly, not, in my opinion, either efficient or effective, and I'll just say has, hampered, I think, what otherwise would have been our inclination to be very transparent with the public and very communicative to the public and tell them what we know as we learn it. This has resulted in some days-long delays in communicating with the public. I think we have now worked around that issue, and I won't go into the details, but very recently we've come to an understanding with NTSB that the work that is being supervised and by COGCC and undertaken largely by Anadarko at this time is separate from the NTSB investigation, and we can share more freely that information more timely with the public. So with that, happy to answer any questions at this moment. If not, we'll jump into these slides that focus quite a bit on the investigation, the environmental investigation.
What was the reason for being a participating party with the NTSB?
Thank you, Commissioner Jolly. Good question. Number one, it allows us to participate, for example, in the factual investigation, including things like the witness interviews. And we felt that that was important, really in both directions, that we actually believe we have subject matter expertise and knowledge that would be beneficial to the NTSB and to everybody, to all the parties involved, to have somebody like Mike Leonard there who understands these flow lines and the engineering and so forth pretty well. And we, while we were interested in hearing what other parties and witnesses had to say, certainly. In addition, there is the opportunity to review draft reports and provide input into those draft reports. We felt that was important. And then I think finally, we understood that the NTSB would be looking to COGCC to understand our regulatory regime. Several of our staff members have been interviewed as part of the factual investigation process. We could have represented them regardless of being a participating party. But in terms of, for example, providing background information and documentation to the NTSB, I think being a participating party has enhanced our opportunity to do that.
Makes sense.
I have just one question about you mentioned the number of Anadarko wells that they voluntarily shut down immediately following the incident. And I'm wondering if you have any information about the status of that. When are they planning on bringing those wells back online? If so, when, and is there any process surrounding that decision?
There is process, Commissioner Overturf. So their intent, as it was communicated to us, was to shut in literally all of the vertical wells that they have in the DJ Basin. And that number is greater than 3,000, but they realized that they already had a pretty significant number shut in for different reasons. So they shut in all of the vertical wells that were not already shut in, and their expressed intent was to inspect all of those wells and all of the flow lines and not bring them back online until they had satisfied themselves that they were safe to operate and that everything was as it should be. I think they've said publicly they have something like a 25-point inspection protocol that they are using for all of those wells. Their announcement had an interesting effect in the especially the public conversation, because in part, at least from our perspective, COGCC understood at that time that we didn't think it was necessary to consider shutting in every vertical well in the DJ Basin, that the circumstances as we understood them were fairly unique and much more discreet than every old vertical well in the DJ Basin. So while there weren't a lot of questions raised, I mean, it did plant a question in people's minds. And I think in the April 27th press conference, we addressed that by saying, that was a voluntary decision by Anadarko, that it was proactive, that, it was an abundance of caution sort of scenario. And the NTO that we ultimately issued on May 2nd is clearly narrower than that, and for reasons that we think are sound.
So I have a couple questions about the NTO itself, and I don't know if this is an appropriate time or if it would be better to go through the presentation first. I defer to you about when that.
I think maybe we have a chance of answering your questions through the presentation. So
okay.
Why don't you see if we do, and then.
Thank you.
Okay. I don't know how I'm gonna, I need a mirror right over Commissioner Hawkins' head. Okay, so this first part of this is maybe less important now than it was a couple of weeks ago, but we have a little history here of the well itself. That was part one, and then the environmental investigation, and Greg will talk about that, and then I'll come back and talk about the NTO. So you already know it's a vertical well. It was drilled in 1993. This is called the Coors V6 14JI. It is to the Codell Formation initially at about 8,000 feet deep. It is a gas producer primarily. It does produce some oil. The well has changed ownership. It has had 4 different owners, and that is not atypical of wells in the DJ. Patina acquired it in 1997. They recompleted the well to the J sand, and so it is producing from both the J sand and Codell. It was acquired by Noble Energy in 2005, and Anadarko acquired the well in 2014 as part of a very large asset swap that Anadarko and Noble engaged in 2014. This is a hard to see sketch from actual PUD filings with the town of Firestone from 1999. What the part that you can't see is the sketch of the proposed streets in the subdivision of Oak Meadows. What you can more clearly see, I have to pivot around here. And maybe I'll actually go here. There's a arrow here to an existing gas well. That is the Coors V614JI. That is the well that was implicated in the explosion. There was an existing gas well over here. This is 1999. This is the flow line that connected the V614JI to a tank battery up at the north side here. And you can see this is labeled on this drawing. All of these labels are right from the drawing, although we wrote them larger and in colored so you could see them. It says existing Patina gas line to be relocated. They've misspelled Patina. So this gives us an understanding that that's where that flow line went up to that tank battery to the north. The tank battery is indicated here. But to be relocated. And then there's a Duke gas line here. This was a midstream gathering line that went through here also to be relocated. So once this subdivision was platted, the plan was to take this line out, disconnect from this tank battery, and put a proposed gas line in here to connect to a new production facility south of the subdivision on the west side over here. So there was the intent to get that gas line out from underneath the planned neighborhood. As part of the investigation, it was determined that this midstream line was removed physically from this area here. Thanks. Okay, so now we've just jumped to a also still 1999, same year, aerial image, and now you can a little bit see that the beginnings of the roads are going in to the subdivision, and we've got a little bit more history here. So here's our well, the Coors V614JI, spud in 1993. This is the location of 6312, the home that exploded. Here was another existing well that was spud in 1993. It was connected to the same tank battery. And there's another well here and another well here. This was the production facility that was later put in. There was another well here from 1993 and another well here from 1998. So 6 wells, 1, 2, 3, 4, 5, 6. This well was spud in 84 and plugged in 85. So that well never really produced much. So you had the 2 wells here going to this northern tank battery along with this well and both of these wells. All of them initially went up this way, and then this production facility was built, and all of these ones to the south went here. This one continued to go here, as did these 2 continued to go to that well, that tank battery, until about 2014-ish. Yeah. Thanks. So now we've jumped forward to 2009, so 10 years forward in time, just to show the development of the subdivision. And the subdivision really did develop from north to south.
And so here you can kind of see, here's the facility that was eventually taken out, but that is still active at the time. Here you can see the beginnings or that new facility that was built. But really, we just wanted to depict the fact that here's Twilight Avenue, and Twilight Avenue still hasn't been built in 2009. No homes along Union Avenue. I guess it's still probably appropriate to talk about this in terms of a hypothesis or sort of an expectation. But assuming that this line went roughly, this flow line from this well in a direction like this up to this tank battery, as these streets are put in, sewer lines are put in underneath them. The sewer lines are deeper than that flow line. The flow line was about 3 feet subgrade when it was put in. They put 3 or 4 feet of fill on top of most of this neighborhood to construct the neighborhood. So the flow line here, when it was excavated, was at about 7 feet below grade. But anyway, you have these sewers being put in. Probably the line is being cut as those happen, and as well as foundations of homes get built, it's likely that that line gets cut as it gets encountered. But as you can see, the Twilight Avenue 6312 was built in 2015. And here is a view from October of 2015. Basically the same thing. The streets have been completed, the houses are built. This shows the 6312 house in place there.
I think I'll try and do it from here. Thanks, Matt. And so again, I'm Greg Duranlo. I'm the environmental manager at COGCC. And so I'm going to go through basically the slides that I presented to the Oak Meadows Homeowners Association and residents, and with some new information that we've put together since that time. So I started by providing just a little information that may be helpful to some in the audience. Hopefully this is going to be redundant to most of the commissioners regarding methane and natural gas. And I will use methane and natural gas interchangeably, though the pure methane differs somewhat from natural gas. Methane is colorless, odorless gas. And because it's colorless and odorless, that's why the service companies, Excel and others, odorize that gas when they provide it to people's homes. Oops, I didn't mean to go forward. The primary hazard associated with methane is fire and explosion. The lower explosive limit is 5% by volume for methane, below which it's too lean to burn, and the upper explosive limit is 15% by volume, above which it's too rich to burn. And 5% by volume equates to 50,000 parts per million. And action levels, we talked about the methane detectors. Those typically alarm at 0.5 to 1% by volume, or 10 to 20% of the lower explosive limit. So there's a safety threshold built into those, so that when the alarm goes off, you have time to react and get out of that environment, call the fire department, et cetera. Methane can be an asphyxiant if it displaces enough oxygen. And generally this hazard, much like the explosive hazard, can be mitigated effectively through ventilation. Methane is considered non-toxic. It's present in the air we breathe. It occurs naturally. It's present in our own bodies. And as an environmental hazard, it's a byproduct of decomposition. So it's present throughout the ecosystem, and it doesn't readily dissolve in water and become a persistent contaminant in water, though methane is a strong greenhouse gas. I think Matt covered this slide in his timeline, so I'm going to skip over it. So One of the first things that COGCC did as part of our investigation was to survey the neighborhood to make sure there were no other areas where methane might be accumulating and concentrating and providing a risk to residents. And so on April 26th, Apogee Scientific conducted a ground methane driving survey of the entire neighborhood, the Oak Meadows subdivision, using their vehicle-mounted leak detection system, which is is shown on the vehicle there. It's got intakes about 3 inches off the ground, pulls in air as it drives through the neighborhood, and can process at a sample rate of 10 samples per second. And it's looking for methane, carbon dioxide, and total hydrocarbons. And so the graph on the right is just an example from their website that would show as they're driving, their instrument readings would tip up if they encountered methane. This slide shows the path that was driven on April 26 to sample for methane in the air. And as you can see, we covered the entire neighborhood, the bordering roads on Firestone Boulevard and Colorado Boulevard. 2 areas of elevated methane were noted during the survey. One area highlighted on the left side of this screen, adjacent to and downwind of the tank battery at the western end of Twilight Avenue. It had detections that were consistent with being that close to an oil and gas operation. 4.5 parts per million methane was detected, and total hydrocarbons were detected at 8 parts per million. We did follow-up screening in the area, and Anadarko later did additional screening in the area, and no other detections were found there at the soil-air interface or around the equipment. It's just sort of latent detections. And again, 4.5 parts per million is a very low detection level. The second area was along Oak Meadows Boulevard, south of Twilight Avenue. And again, methane was detected at a low concentration of 4.5 parts per million. And again, this area was downwind of the tank battery. However, when we screened in the area with handheld equipment, we found inconsistent readings of up to 200 parts per million, which indicated that further investigation in the area may be warranted. I don't think we put 2 and 2 together right away with respect to the flow line. So the following day on April 27th, LT Environmental began conducting a soil gas survey of the area primarily around 6310 and 6312 Twilight Avenue. The soil gas survey included the installation and screening of 30-inch deep sample points on a 75-foot grid, as Matt described earlier, to cover the properties along Twilight Avenue in that vicinity. Each soil gas survey was installed with a slide hammer, and a temporary sampling tube was inserted into the ground, and then a handheld instrument was used to read methane, carbon monoxide, oxygen, hydrogen sulfide measures in the ground. And occasional samples from that effort were collected and sent to the lab for gas composition and isotopic analysis. So a little bit about soil gas surveys. They're a great screening tool. As you heard earlier, there was soil gas surveys conducted in Quebec also. They're typically used to guide further assessment. They're not intended to quantify the amount of gas present in the subsurface or provide a final assessment as to where and how deep the gas may be. But they are used commonly to guide further and more thorough assessments. So this shows the area that we conducted our initial soil gas survey around the properties at 6312 and 6310 Twilight Avenue. And the results from this area showed us that only around those 2 properties did we find methane detections in the soil. So the outline, we stopped when we reached background concentrations and didn't continue our survey down the road. We had reached the end of it. However, when we reviewed the data from the Apogee survey, the LTE soil gas survey data and notes from COGCC field staff who'd been present at the site, it became apparent that there could be methane in the western, in the vicinity of Oak Meadows Boulevard, south of Twilight. And so beginning on May 5th, COGCC with LT Environmental began investigating a second area for the presence of methane.
What is that building, that large building?
This is an apartment building that's under construction. So these are garages here and an apartment here, apartment here, apartment here. And you can see, and in the difference, I mean, it's just developing fast. So the current 2015, current 2015 aerials don't show it. The Google Earth images show the beginnings of some construction happening. And we actually had the area flown with a drone during our investigation to get up to the minute pictures. So this shows the second survey grid. As Matt said, our initial sampling on that Friday, I should have highlighted these in a different color. We're right in this area and showed significant concentrations of methane. In fact, it was 100% methane by volume in the soil. We then came up here to the north of this bike path and installed additional soil points to make sure that it wasn't going north into those residential properties. So, yes, you may.
Tell them about the contact of Public Works with that sewer line of the road.
Yep. So there are a number of manholes in this area. And again, because we had, this shows the location of the 1-inch return line. And because, you know, our information said it was truncated under there, we suspected that it was the sewer that had cut that line. And so our first thought was that sewer could be a conduit carrying that gas up into the neighborhood or south down to Firestone Boulevard and beyond. So we called Public Works, got them out there, opened manholes. You can see this manhole in the image. I'm not sure, this is another one. There's another up here and another up here. So we surveyed 4 manholes in that vicinity. And there, of course, was methane in the sewer. But the levels were, as the Public Works guy described them, they were normal. They were nothing that he was concerned about. So the soil gas survey were evaluated and 2 residual source areas of elevated concentrations of methane were clearly identified and fully delineated. You can see over the time of our investigation, we installed monitoring points outside the boundaries of any concentrations of methane that we found, and then, you know, didn't need to go further than that. COGCC used the data collected by LT to develop this contour map, which shows the areas of highest concentration and illustrates that the methane was not threatening these homes up here or these residents beyond here. You can see we had a pretty tight concentration of monitoring points there to make sure that this home at 6304 was not being encroached upon by methane. In addition to the soil gas survey, COGCC also installed more permanent monitoring points at select locations between those identified source areas and the residents. So here we installed 1-inch monitoring points, PVC screened from 5 to 10 feet below surface, where we could go back in and take repeated measurements of the soil gas and make sure that nothing was migrating. These triangles are, we also installed a couple of 2-inch monitoring points that could be used to vent off gas. So to kind of summarize our survey, we found that soil gas was limited to 2 distinct areas, the eastern area around 6312 Twilight Avenue, and the western area at Oak Meadows Boulevard south of Twilight. The lateral extent, by the time we held the meeting at Oak Meadows Homeowners Association, had been delineated, and the monitoring point data indicated that methane in soil was not migrating towards occupied residents. As Matt mentioned, the homeowners at 6310 had not returned to their home. So along that time, we started communicating with Anadarko. And beginning on May 4th, COGCC engaged Anadarko to begin conducting their own investigation of the release of gas consistent with our rules. And their investigation over the next month included a walking survey for methane in that area and along Twilight Boulevard, subsurface investigation to assess the lateral and vertical extent of methane in the soil, installation of monitoring points and vent wells, sample collection for laboratory analysis, and ultimately the remediation of the residual source areas. This slide shows the walking survey that they conducted. Their contractor used a flame ionization detector equipped with a funnel device that detects methane directly at the ground surface. So they lay the funnel on the ground, collect a sample out of that, and look for gas readings. Their coverage was extensive in the western area, east of Oak Meadows Boulevard, excuse me. And they were able to, at this time, the 6310 and 6312 properties were fenced out, so they didn't have access to that. But you can see they had detections outside that fence line and then in this area that we had identified. So that's what they're seeing at the surface. No other detections were found as they walked that area. Anadarko began to investigate the lateral and vertical extent of gas in the soil on May 5th using a membrane interface probe to install soil borings up to 30 feet deep. The MIP allows for the assessment of hydrocarbons in the subsurface as the probe is advanced to depth. So it's sort of a instantaneous, they can get instantaneous readings of the soil as they're going down. Then when they pull the probe out, wells can be installed to provide long-term sampling and monitoring access to those points. Again, access at the eastern area was limited at the time, so they focused their investigation on the western area. And they, during that period of time, they also converted COGCC's 2 vent wells and many of their own vent wells to sort of passive soil venting wells with little whirlybird vents on them to try and draw gas out of the ground and create, negative soil pressure to make sure that any methane, free methane in the soil didn't migrate. Through May 31st, Anadarko has advanced a total of 54 soil borings throughout the investigation area. In all, Anadarko established 63 monitoring points from which gas readings have been collected nearly daily. This includes 17 points along the south side of homes, along this area, which were kind of used throughout the process as sentry monitoring points to make sure that gas from the areas of known concentration weren't migrating towards those occupied homes. They also incorporated COGCC's long-term monitoring points into their system. Gas concentrations in the monitoring points where gas was detected have declined initially slowly with the passive venting, and then I'll talk about an SVE system, soil vapor extraction system, which was implemented, and we started to see dramatic rates of decline in the soil gas measurements. So on May 17th, at the request of COGCC, Anadarko installed a soil vapor extraction system in the area east of Oak Meadows Boulevard, connected to 6 vent well monitoring points in that area, and those are the yellow points here. Initial monitoring of the system indicated that the system has been successfully removing hydrocarbons from the surface. As of May 31st, the system had removed over 1,400 pounds of total hydrocarbons, and the removal rate had dropped from an initial rate of 700 pounds per day on May 18th to a rate of 3.2 pounds per day on May 30th. And that's what we expected to see. We expected the methane in the soil to be trapped in the pore space and not absorbed onto the soil particles, and we expected it to be removed relatively easily, and it appears that those data show that it was. However, due to persistent methane readings in well VW21 here, it was connected to the system on June 2nd, so they expanded the system out there to pull that down. On May 24th, Anadarko installed a second SVE system on the 6310 and 6312 Twilight Avenue properties. This system connected to 3 shallow and 3 deep wells, so they sort of installed, they weren't nested wells, but they were installed next to one another. Some screened to 10 feet and the other screened from 10 to 20 feet. And they connected those wells to the system. And again, same thing, we saw pretty rapid removal rates in the eastern area as well. As of May 31st, again, the eastern system had removed over 675 pounds of hydrocarbons from the subsurface, and the removal rate there dropped from 564 pounds per day on May 24th when they started it to a rate of 0.35 pounds per day on May 30th, so a much faster decline over there. So on June 7th, both systems' removal rates had declined to 1/10 of a pound per day or less. And this slide just shows the eastern system along Oak Meadows Boulevard. We got a lot of questions at the Homeowners Association meeting. What are those white pipes out there? What are you guys doing out there? This is depicting the SVE system that's installed out there, pulling the gas out of the ground. So based on the removal rates dropping to very low asymptotic levels, COGCC and Anadarko agreed to shut off the SVE systems and monitor the vapor monitoring points to determine if concentrations rebound. So the systems were shut down last Wednesday, and Anadarko monitored all 63 wells Thursday and Friday and found no rebound. They are out there this morning checking again to make sure that nothing came back over the weekend. Again, this was what we expected to see. We might have expected to see some rebound. That's more typical if you have a latent source, such as dissolved phase in the groundwater or hydrocarbons absorbed to soil particles that continue to give off gas into that pore space in the soil. In this case, with the pure methane going into the soil, we expect that it would be removed effectively with the soil vapor extraction, and it appears that it has been, though we won't take 2 days of monitoring and say we're done. We will be looking at that and potentially drilling some additional monitoring points between other vent wells to make sure that nothing is left in the ground. And then we'll make plans for decommissioning the system. So that's, I would say, very good news at the end of that presentation. And one thing I should also mention is that from the moment the Environmental Health and Safety group at Anadarko became engaged with us, or we became engaged with them, they did everything that was asked of them immediately. No pushback. They were extremely helpful, extremely good to work with, and it was some very challenging conversations with their group and our group. We were having daily calls. We all collectively agreed that we would not start our calls with the formality of asking how each party was doing. It was an unnecessary lie that we told each other, and it was challenging. But I should say that Paul Schneider, Eric Mickelson, Linda Scranton, and Sean, I forget Sean's last name, Kyle, Sean's. Okay, so anyway, their counsel were just great to work with, and I certainly appreciated everything that they did.
Thanks, Greg. Actually, I want to relate just one small anecdote around this whole issue that I think illustrates in part I don't know, randomness and chaos and all of the things that were going on. Over here on the ground is this little thing that Greg referred to as a whirligig, which I think is the official term. And the whirligig you would normally put on the top of one of these, and it's a passive system for drawing methane out. That whirligig spins in the wind, creates a little bit of negative air pressure, and that draws the methane out. So that was what we asked Anadarko to install when they first really started their activities at the site. And I was out at the location on Friday, May 12th, mostly to participate in the witness interviews from NTSB. And that was the first day that Vista was really out there, Anadarko's contractor, working hard on this system. And on Friday, I could tell that they hadn't made as much progress as we hoped they would. I think I went back on Monday, and they were getting the system in place, but there was a shortage of whirligigs. So this whole complicated thing was being held up by the absence of their ability to find those thingies to stick on the top of these. I think it was that same Monday afternoon that I had a long conversation with the town officials from Firestone, the Frederick Firestone Fire Protection District, the fire department, the police department, to update them and describe for them what we were doing and where we thought it was all going. But one of the things that came out of that conversation was that, you know, time was ticking away as they were looking for whirligigs, and we weren't sure how effective the passive system was going to be. And we told Anadarko, I think on Tuesday, May 16th, you know, we need to get results back quickly and see if this is effective or not. And if not, we're going to go to the SVE, the active system, quickly. Well, Anadarko took the initiative to switch over to the active system the very next day. So we went from that passive system was in place for about a day and a half, honestly, before they installed this active system on the 17th. And for the reasons Greg just described, it appears that the active system is working. So we are brushing up against lunch. If Mark Morton is out there in the hallway, Mark, did he go over to the lunch? Okay. All right. We'll maybe we can move through this quickly, and maybe if there are questions, we'll let you decide if you want to. We've got some local officials waiting for us.
Would it be better to
you want to break now?
Break now?
Okay, that's fine with me.
If that's acceptable to the rest of the
Absolutely.
commissioners, because then that way we would get to see the NTO and then have the opportunity to ask questions.
Fine.
Okay, so the lunch is at the Mountain Valley Bank. It's at 400 Main. So, okay, again, this is for commissioners. So go out the main
All right, we'll go ahead and get started. I know Director Lepore is on his way back, but we may have some questions for Mr. Duranlo, so we'll proceed ahead. So, Commissioner Hager?
All right, I'm gonna call it west of that Oak Meadow Drive, where that extension of going in that direction.
Right.
Has that just been tested by the drive-by surveys? No soil gas over there?
Yeah, okay, so I'll back up to a map. So the portion of the 1-inch flow line between Oak Meadows Boulevard and the T here that Matt mentioned, Anadarko exposed the flow line right out in this area and tested the integrity of that 1-inch line between those 2 points. And so there was integrity from here to here. And with the review of the construction documents that were in Director Lepore's earlier slide, looking at where the sewer would cross, and there was actually some profile drawings in that same design package that showed the depths of the flow line through there, and it was always labeled as to be removed. We felt pretty certain that any gas that was in that flow line would have come out at this spot. And so to the west of here, I mean, we did enough testing to know that we had gone beyond the boundary of that area of residual gas. The only other testing we did further west of that was there at the tank battery. We did a survey just with handheld instruments. Anadarko did put a couple more soil points in that area. I guess they did not go further. They did not go further west than ours. They did they called it their sniffer survey with the flame ionization detector over at that tank battery, and maybe that actually is shown in this. So they did walk that path that way, and you know, this detection here is right at a wellhead, so you know, that was a very low level, which would be typical of being right next to a wellhead.
Right. And it doesn't look like there's any way that flow line west would have been cut. My concern would be, could some of that methane that's still trapped in the soil right now flow along a cut pipeline as its conduit, and we missed it, but there's no road or sewer line, it looks like, going through it.
Yeah, I mean, that was the point of walking this path right here. They were walking along on top of that flow line to determine whether that was acting as a conduit.
Okay, and then those on the north side of that survey against the houses, are those green dots, were those hits of methane?
Up here or?
On the next north, that one,
This
that
one?
transect.
Yeah, so those are coming out at 2 to 100 parts per million. So I can't tell you the exact amount, but there were a couple of anomalous readings that, you know, here that appeared to be just that.
Yeah.
Anomalous readings.
Right. They look about the same size or the same concentration as the one at the wellhead over to the west. Just curious.
Yeah, and again, I don't know the exact concentrations, whether that's on the low end of that 2 to 100 or higher up.
Right. Okay, and then
again, I guess one other thing I would say though, on those, you know, even at 100 parts per million, you're at 0.01%. So we're very, very low concentrations.
Right. Since the SVE system has been shut down, it's being monitored. Is that continuous monitoring? it sounds like they're going out during the day to monitor, but temperature, winds, and atmospheric pressures can affect where that methane's going to go. Are they monitoring that at different times of the day, or do they have a continuous monitor?
So we have
installed?
been, we initiated and they continued just daily monitoring of those sample points. The vapor monitoring points are sealed at the top. And so they go down, they open the seal, insert their probe down into the screened interval down in the soil. So they're typically the screens are starting at 5 feet below grade. Some of them start at 10 feet, but they're down inside the screened interval where they're actually collecting their sample from, and drawing that sample through their equipment.
That makes sense. And then the deep and shallow wells that were installed at the same time, was that just precautionary, or was there something in the data to suggest that there were different levels of soil gas with methane in it?
They actually just felt that would be a better way to approach the soil vapor extraction, and then they could control it better if they found different, different responses from the different depths.
Mm-hmm.
It turns out it may have been unnecessary. We probably could have installed just one well with continuous screen, but that just gave them more control of the system.
Okay, that's all I have.
May I ask one question?
Certainly.
Thank you. Earlier when we were walking to lunch, you and I were having a conversation about approximating the amount of methane that was ultimately released or vented into the air. And I just wonder if you could summarize your very rough estimations for the benefit of the other commissioners as well.
Sure. So I'm not sure that I'm able to estimate the amount of methane that was released through the 1-inch flow line. I can say that, Anadarko has monitored, and they've both, screened with instrumentation, handheld instrumentation, the effluent and influent to their SVE system, and they've collected laboratory samples to verify those screening measurements. So, and Director Lepore mentioned earlier, the data was kind of coming in fast and furious, and we're trying to process it and make decisions, and then would make a decision and the data would change because it was based on, a field screening, and then the laboratory analysis came in and changed it. Things like that happened during this project because it was fairly fast paced. So now that we have solid data from the time they started operating their system, in the eastern portion, and I guess I'll go back just so we have that map up. In the eastern portion, 675 pounds of hydrocarbons from the surface. And I don't have the exact composition in front of me, but the majority of that is methane. We think in the western portion, we have no reason to think that we haven't, if we've removed all the methane, we have no reason to think that there was other methane released to that area. In other words, we don't think the methane naturally vented out to a high degree. We think it went into the soil, filled the pore space. Some probably came out over time. We may never know what that is. I just kind of threw out a wag as I bet 98% of it was in the soil and we pulled it out with the SVE system. I don't think we will ever know the answer to that question. We will ask Anadarko to provide us with an estimate of the amount of methane released, but I don't know that we'll ever know.
Just wanted to make sure I understood this too. The primary production from that well was flowing into a 2-inch flow line over to the facilities. And this was just a secondary, what would you call it? Why would we have 2 flow lines like that? One's temporary?
So structurally, the red line represents what has been referred to as a 1-inch return line. It's a polyethylene HDPE pipe that is typically employed to return gas from the separator to the wellhead and act as wellhead control gas. So it would run the plunger lift, it would run
So
the
just do like a little bit
instrumentation
of additional lift.
at the well. In this case, that line was receiving gas from the well, which in some instances it does flow both directions or either direction in that line. In this case, it was only capable of flowing one direction, and that's a well flow.
Okay, I guess I was just a little bit confused. I know it didn't really serve as the primary producing conduit, but it was obviously filled with gas and leaking.
Right. And actually, Director Lepore may have some pictures that'll help in the NTO section. Do you? Yeah. And I wanted to say one other thing. I acknowledge the work that Anadarko did in their investigation. I should also acknowledge the folks that we hired to do work. LTE Environmental, Site Services, and Dolan Integration Group, and Apogee all kind of dropped everything to help us out. There was a real, the support that we got from those folks was great. We rushed our analytical samples through Dolan, and they normally have 100% markup for those rush samples, and they knocked the 100% markup off. And Site Services is a drilling contractor. You usually call them up and they're like, yeah, we could be out there in 2 weeks. And they were out there same day. So just the level of, I guess, publicity on this, I mean, everybody was very, was super helpful. So anyway.
No, you don't find keep talking.
I think,
Thursday.
yeah. There was a map that was passed around to the commissioners, I think, that provide a little bit more of a layout for where those lines ran. Yeah. This might. So you see that just went up there originally. Yeah. That was the original facility was up there. Yeah. Got cut right underneath the house and probably got cut all the way up through there too. Okay. All right, I think we'll continue on with the notice to operators in place.
All right, thank you. So I think I made these points earlier. The purpose of the NTO was to require operators to take steps that would hopefully, based on our understanding of what occurred here, to minimize any possibility that happens again. And I mentioned that we had inspectors and engineers embedded with the operators to participate, witness, et cetera. So maybe this picture will help a little bit. This is not the Coors V614JI that was closest to the house, but this is a Anadarko owned and operated Coors V6 well that was to the west. And here you can see two inactive risers. This is a 1-inch riser. Riser just refers to the rigid portion coming up out of the ground. Here's a 2-inch. This is a steel riser. So this is very similar to what we saw at the V6 14JI, except that the 1-inch riser had plumbing on top of it that was plumbed to the well. This riser has a valve there, but the handle has been taken off of the valve. The 14JI had a valve with a handle. Here, this has been properly blind plugged, and can't tell if there's a tag on it, but what we would require, the NTO will require a tag on that. But anyway, two, not being used and essentially well abandoned, that is, no valves that could be opened. The well has these active risers, right? So coming up out of the ground, plumb to the well, through various lines and connections. In 2000, Julie Murphy might have to help me, in 2001, we required abandoned line of the cut below grade. Right. So our current flow line abandonment rules do not allow these risers to remain above grade. As of 2001, if you abandon a flow line, you have to cut these off below grade. We didn't make that rule retroactive. We don't make our rules retroactive most of the time. But had we made that rule retroactive, that's one way to prevent a recurrence of what we think happened here. So one part of the NTO is that all of these lines, all of these risers that are not in use must be cut off below grade, consistent with and pursuant to the current version of its Rule 1003.
1103?
Is it? Oh, it is. It was 1103. Thank you. Sorry. Thanks, Bob. Does that help? I mean, maybe if you have questions about what you're looking at, ask me now, because I'm going to go on to different pictures. And what I was looking for that I think I maybe have on my computer, but not on my flash drive, is a picture of the actual valve that was involved. That valve still had the handle on it. And in the picture that was taken the day after the incident, the handle is in the closed position. But we know that on the night of the incident, following the incident, when Anadarko arrived at the scene, the person for Anadarko who arrived has said in a videotaped interview that that valve was open and he closed it. So it would be in the open position flowing into a flow line that went nowhere. So that's really the second part of the NTO, or the other part of the NTO is any line that appears to be used, you have to identify, operators have to identify point A and point B. Where does it start? Where does it end? And pressure test the line in between, right? So if that had happened at the Anadarko Coors P614JI, there'd be no pressure because it's an open pipe. Then that would tell you something was wrong. Okay, so there were two parts, and I've already kind of foreshadowed them for you, but part one of the NTO is limited to either wells or facilities within 1,000 feet of a building unit, and that's under our rules an occupied building. And the idea was by May 30th, inspect all of those flow line and make sure you know point A and point B, like I just said, and document those, that point A and point B. And by our IT staff was able to have a database of building points, address points. And the address points are, first of all, not just limited to occupied buildings, and second of all, not always extremely precise, but it was still a good starting point. And based on that address point data, we calculated approximately 15,000 wells would fall into that 1,000-foot domain. So we were asking operators to go inspect about 15,000 wells in roughly 30 days and identify point A and point B for all of these flow lines. Then by June 30th, so sort of 60 days out, required to have pressure tested those lines to ensure that there's integrity to the line. The second part of the NTO is that forget about distance to a building unit. We want you to go identify all abandoned risers, and recognizing that the rule changed in 2001, nonetheless, we want you to paint with fluorescent paint any unused, inactive line and either plug it out or tag it out and lock it out so that it it can't be used the way it exists without some pretty meaningful effort on behalf of somebody. Enough effort to make them stop and think, why am I about to use a line that clearly wasn't, somebody's telling me not to use it. That was to happen by May 30th, and by June 30th, it's to cut off all of those risers below grade, just like our rules currently require, even if they had abandoned those before that rule took effect. We did include a provision for instances in which an operator wanted to bring that currently inactive line back into service. We understand that scenario does take place, and we wanted to allow that to happen as long as it was done safely. So this is a little bit of a demonstration of a flow line that has been properly painted. It has been tagged, and it's not locked out, but it is blind plugged out. So that's the plug at the top. You got to show up with tools and ignore the tag and ask yourself why it's painted orange, before you do anything to this particular riser. And that this is an acceptable way to do this under the NTO as of May 30th. So now if we go out and inspect and see a line that's a riser that doesn't look like this, they are essentially in violation of the NTO. And then, the question becomes why and what are the circumstances and things like that. And then by June 30th, we'd expect this to be cut off below grade. Here's one in which they have determined that they want to return this line to service. So they have pressure tested it and tagged it for the time being, with the understanding that in the future they will probably reconnect to that line and go ahead and use it. So that's why it's not painted, and why it has that valve handle on it. I think that's all I got for that. Happy to answer questions.
Thank you. Very useful. Any questions for Director Lepore, or any additional questions for Mr. Durano? Yes, Commissioner.
Thank you. The GPS information about point A and point B for each flow line that's being tested as part of the NTO, will that information be publicly made available through the Commission's database?
The short answer is yes. Precisely how we do that is still something we're kind of grappling with. The process has been that we created a template electronically and pushed that out to all operators and said, please put your data in the template and then email the template to us. And they've done that, but sometimes they want to be helpful, so they add spaces between fields or put NA in fields or do other things that essentially corrupt the database. So we have to go clean it up, and then we import it into our database. So when it's cleaned up and imported into the database, then we will make it available. And again, sort of in what form and all that, I think there's a little bit of thought to go into, but essentially everything that was submitted to us by operators will be available to the public.
Okay. And then I'm curious as to what was the rationale between requiring the GPS information for point A and point B, but not for everything in between? So it seems to me like from point A to point B can be pew, or it can be la, 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 and that knowing exactly where the actual pipe itself is really valuable in terms of not having somebody else through mistake or negligence or whatever, cut another line that happens to have product in it. And so why was the actual information about the locations not required?
There are a number of reasons. The biggest one is really probably time. So what we wanted in the short term was to understand that if it's connected here, it's also connected there. To us, that was the single biggest factor here. It was connected on one end and not the other. So knowing that it's connected is extremely important. Next, knowing that it has integrity, regardless of its direct line or its meander. If you pressure test it and it holds fluid, then, or holds pressure, then it shouldn't be putting methane into the environment and things are okay. Surely somebody could come along and cut it with a backhoe or something like that. If it's an active line in use under pressure and they cut it, they're going to know it, should know it pretty quickly. So I think there's probably robust conversations in all of our future about mapping those flow lines, but the immediate concern for us was more point A, point B, and integrity. Operators are required to register with the one call service, which is 811. All these lines post, I don't know what date, somebody, Tracer? 96? Okay, is that right? Yes, 96. Okay, 96. You could trace these lines with magnetometer, find the route. And so again, that might be something that happens in the future.
Are you concerned at all that I can imagine if you're an operator and you've made this seemingly Herculean effort to come into compliance with the NTO and the timelines that were provided, that there was kind of an opportunity there to be efficient and do both at the same time. And my concern is that maybe we've missed a little bit of an opportunity. Do you share that concern, or?
I think that some operators may have done that voluntarily themselves, and that's really my answer, is that if they wanted to take that extra step while they had crews and people in the field, that is entirely up to them. Some operators have told us they do have maps for their flow lines. But again, really my calculus was we are asking them to do an awful lot in a really short period of time. And that if we were going to include mapping, probably not, didn't seem realistically doable.
Okay, that's very helpful. Thank you.
Mr. Chairman, thank you. Matt, great presentation, very helpful. Some of my questions just answered with your responses to Commissioner Overturf, but I want to follow up on a couple of them. So what happens if operators don't fully comply, and how do you even know? Because, right, they're just giving you data and you're assuming that their data are complete and accurate. But what ways do you have of verifying that?
So good questions. One, that's one of the reasons we sent operator inspectors into the field and engineers into the field, at least to observe some slice of what they were doing. Second, it will have to be part of our ongoing enforcement is verifying some of those pressure tests. With the location data we have, longitude, latitude, GPS points, and we should be able to go to a site now with that information and see if it sort of checks out and lines up. And part of the question is the same way we know that operators are complying with any or all of our rules, which is it's somewhat trust but verify. I mean, we can't watch them do every single one of these things, nor can we go check every single one of them. I mean, I do have somewhere, I think I have the statistics of what has actually been done, and we have reports now on more than, let me see if I can find the right piece of paper. Might be over there somewhere. Something like 16,800 wells have been covered by the operators so far as locations of things.
And that matches up pretty well with what you're...
It does match up pretty well. We know it's not a perfect match yet, and that's, the ongoing process is to try to line up. So from our set of what we predicted before, we have now circled back to operators and said, according to our data, these wells, XYZ, were within 1,000 feet of an address point, and we don't have a report from you. Can you tell us why that is? And the answer might be, turns out it wasn't an occupied building, would be one answer. The well had an improper status in your database. It's really not an active well. We filed a P&A subsequent, and that P&A subsequent is in your database waiting to be processed. But we want to check all those things.
But you have a pretty high degree of confidence that you've gotten a very high level of compliance and response.
I think the response and the compliance have been very good. I think there's some cleanup to do.
Okay, good. So my next question is, you've dealt with now with flow lines that are within 1,000 feet of occupied building units. There's a lot of new development that's going on out there. And there will be additional occupied units within 1,000 feet of a number of wells that don't currently exist. So is that sort of the next phase, or will operators, as new developments are constructed around them, are they going to be required to do the same kind of analysis, or what?
So operators are currently required under our rules to pressure test their flow lines annually. So those lines should be tested for integrity annually. One of the things that we need to look at, I suggest, is there's currently in the rule a carve out, an exception for low pressure lines. And low pressure is supposed to be 15 PSI or less. I think that rule should be looked at as to its continued utility and whether low pressure is the right definition. So one of the issues that's come up in this conversation is that there are lines that are by design open-ended that dump into, for example, a produced water tank. All right, well, that's a low pressure line, right? It's gravity fed. Might not, pressure testing that annually might not make sense because there are complications with pressure testing it. But the return lines that were at issue here, probably, maybe, possibly operators don't test them under that exception, and probably, maybe, possibly they're not really 15 PSI or less. So maybe that exception is something to be looked at.
Mm-hmm.
But beyond that, then they should be doing integrity tests annually, and I think that's on us somewhat to make sure that that's happening, enforce that. So I don't think we've touched much. This flow line integrity group that we've referenced a couple of times is new as of 2014. And it was developed following an analysis that we did internally of all of the spills that we have responded to since roughly 2009. I'm not sure I remember the start date, but about 5 or 6 years of data we looked at to see what kinds of operations lead to these adverse environmental outcomes. And storage tanks and flow lines are pretty high on that list. So we created this group within the engineering group. We've got 3 people staffed on that now. They've been working closely with operators on flow line integrity testing compliance. And again, another effort that's probably part of our future conversation about how robust that program should be, is.
So you may not be able to answer this, but I'll ask it anyway. Is it too soon to be talking about lessons learned? Is this sort of a sui generis situation, just a terrible confluence of circumstances that is highly unlikely to recur, or are there some underlying factors here, which presumably the NTO was intended to get at, but that could suggest that there's an endemic risk, which is of course what all the people who live in the area are concerned about, and all the postcards and emails that you're getting are focused on that, on what's the risk to the public. So that's a convoluted question, but it's basically, is it too soon to draw any conclusions from what you've done so far?
Well, there's a lot in that question. I guess that at my core, I think what happened in Firestone was a confluence of a number of specific circumstances that spans 18 years. Any one of which, had it not happened or had something slightly different happened, this may never have happened, this fire and explosion. So I don't think this is commonplace, and I don't think it's endemic. I do think that the NTO gets to things that are widespread in the gas patch, the abandoned lines not being cut off below grade because it wasn't required until 2001. Potentially using one of those abandoned risers just as a standpipe to connect some plumbing to, and then somehow it gets itself connected and things like that happen. These facilities change hands over time. I think one of the factors here is that there were 4 different operators of this well over that 18-year span. Those things happen, and institutional knowledge changes and personnel changes and things happen. So I do think the NTO addresses things like that. And the last part of your question, I absolutely don't think it's too early to think about changes. Mapping the flow lines has been kind of foremost on everybody's mind. Again, I think there's a robust conversation there. I don't see that as a panacea. I see a lot of good, but I don't think it's don't think it solves all of our ills. But I think we have to think about it. I think this is an opportunity to raise performance, both among the regulated community and among ourselves.
One of the things that struck me in both this presentation and the one earlier about Quebec was the importance of, or the usefulness of, methane testing and the technologies that exist for covering a relatively large area in a short period of time. And I'm wondering, with very sophisticated instruments, and I'm wondering whether there's something that the commission can do now with some of these local communities to do some additional methane testing to at least settle some nerves in terms of, there's no, just as you established, there really were only these 2 hotspots from this particular well. Maybe there's a way to sort of expand some of that work to give people comfort.
So I think, make sure I have Director Randall's attention. These conversations like this are being had at COGCC, at the Department of Natural Resources, at the Department of Public Health and Environment, and at the governor's office. A lot of people paying attention and thinking through these things. And that topic is also, I would say, top 5 of the list that grows and evolves. But some idea about surveys of methane are a recurring theme. We sat down, some of us, with a company that does aerial surveys, and kind of our walk away from them was that their business model was to identify the super emitters, really. I mean, that's what, so if you're familiar with that term, and sort of methane in the environment from oil and gas. So their detection limit was not probably where we would want it to be, because you saw the driving survey did find that spot, but it didn't send out screaming alerts at all. There's been conversations about the FLIR cameras, and CDPHE does a lot of FLIR camera work, but they don't go try to find the path of the flow line. They're on the location looking at the wellhead, and maybe at the tank battery looking at the tanks. So there's, so we have to carefully define the problem, as Commissioner Craig would have warned us all, cautioned us all, and then find a technology that works. We've talked about drones. We've talked about driving surveys. Then you got to identify the resources and start, which neighborhoods get to go first. So these are, I'm going to make all of this as much your issues to decide as I can, but those are real things to talk about. Commissioner Benton.
Commissioner.
I think Commissioner Walk would like that.
I'm waiting. Go right ahead.
Yeah, I mean, just to follow up on the peace of mind part of the question, I mean, each of us has a role and everybody's stepping up. I mean, to Director Lepore's point, I mean, we're full core press on really the assessment phase of this. And so that was part of the reason for my asking this question about when you provide the monitors, that's great, but then who's on the other end of the phone? What's the phone number? What's the organization, or who's the entity then that's the right entity when a monitor says, hey, we've got too much methane, or maybe it's a nondescript gas, or am I calling the utility company? Am I calling CDPHE, COGCC, the local, whatever? So we're trying to simplify this to make it an easy process. I will say, and probably unbeknownst to most of the commissioners, CDPHE, as a result of the task force that was created a few years ago, and then ensuing legislation, has a mobile assessment unit that went live 6-8 months ago, maybe, if that. Maybe 4 seems so long. But part of the rationale for this unit is to go out and do these community-specific assessments when we get enough concern expressed from a particular neighborhood or community around the state, and do some monitoring and send some air folks as well as some epidemiologists, as well as the best science that we have to apply to see if there's cause for that concern, or if we can provide some reassurance. And we've done now 4-ish assessments to date in a number of different communities, all of which have come back in that category of reassurance, that in spite of a strong odor or a strong sense that there may be something going on in that particular neighborhood or community that may be causing harm to an individual or family or group of people's health, that just hasn't been supported by the evaluation of the air inventory that we're able to do as a result of the unit. So just an example of like some of the other work that goes on in addition to the work of COGCC.
Which now brings a question. Where is that information, when you do something like that, where is that made available?
It's posted on our website. So as part of, again, that task force recommendation and the ensuing implementation is we at CDPHE were to create this clearinghouse, which I use broadly, that term broadly, which includes a place for anyone to come with a concern or a complaint or a question if they have questions. And then we have then the resources, whether it's online, by telephone, whatever it is, to direct that concern or complaint to the appropriate entity, because it could be a local oil and gas liaison, it could be COGCC, it could stay with us at CDPHE or wherever, because a lot of times we get questions about mineral rights or pooling or whatever, and so we know to sort of direct that to the appropriate place. So we have now a place on our website so that if you Google it, you should come right to it, and you can see then as we finalize and then send these reports out, we also post them to our site. And then that's the mobile reports. Then we're also doing these aggregate reports based on the number of calls we get, based on the number of inquiries we get, what percentage of those are health concerns. Of the health concerns, what percentage, looking at each of those concerns, is it bloody noses? Is it respiratory complaints? Is it concerns about cancer? Whatever it is. And so we've since, and that's been in place actually for quite a bit longer. That's easily a year. Yeah, and so there's already been a report, but it all gets posted under our website.
So what I heard there was that generally it's where someone has contacted you as a result of, they smell something or there's something in the air, and then you go out and do a survey.
So we still have the opportunity to decide whether or not it warrants sending out the unit. So if it's a single complaint, we try to work with who's ever making that complaint. But if we get, I'd say our threshold's pretty low, any more than maybe 3 to 6 in a particular geographic area. And again, the epidemiologists have the thresholds developed depending on what the complaint is. Then that's what will allow us to go ahead and send out the mobile unit.
I think sort of my concern is that in this particular case, and in most cases where it's a methane leak, it doesn't smell. And there isn't. So it's a lot of time what your process starts with someone who calls and talks about and says there's an issue with some odor or something, or like something smells bad, or it's giving me a nosebleed or whatever. In this particular case, and I've mentioned this to the commissioner and to the director, is that are we sort of, and I think we've taken a lot of great steps here to identify potential future issues, is that now that this has happened, what are we doing to sort of stay ahead of it and as best as we can?
So you raise a good point, and as Matt said, as different groups have talked about this, including the governor, we're asking questions then about, well, is there technically and or financially and practically feasibility to, what's the word, odorize? Thank you. Okay. Odorize, it's a new word for me. Odorize, methane from oil and gas operations. And so, looking at every one of these possibilities. I don't think it's odorant. It's a different odorant.
An odorant. We're captain.
Adding an odorant.
Adding an odorant.
Well, if you can have a deodorant, you must be able to have an odorant.
You could. Any other?
I just have
questions?
one.
Certainly.
This one's probably hard, but we're talking about all the different agencies and groups that are involved in addressing this, and there's a lot of brainstorming going on. And can you potentially summarize what role those groups play? Like for the COGCC, we regulate integrity, and now through the notice to operator, points A and B, and that's all for flow lines. What other, we certainly don't have setbacks, I know that. Do counties have setbacks? Do any other groups have setback rules? Are any other groups looking at that?
Setback from the line.
From the flow line, not from the wellhead.
So you're correct that we don't, and I can't answer you as to whether anybody else does. Someone said to me that they thought Broomfield either does or is thinking about imposing a flow line setback. Again, I think best thing I can tell you is that everything's fair game for what's on the table. I was part of a conversation around flow line setbacks, and where do we start? Do you start with all the existing flow lines, or is it just flow lines that get built in the future? And is it a local government land use regulation? Is it a COGCC regulation? What does that mean to the housing industry? I mean, for those of you that weren't part of the fun of setback rulemaking, the Home Builders Association was a very active participant in the setback rulemaking because This incident has triggered the conversation about reciprocal setbacks. So we set setbacks from wellheads to existing buildings. We don't have authority over setbacks from new buildings to existing wells. And those setbacks have lots of implications for how many houses get built in a given area of land and the price of those houses and good things like that. And to me, that picture gets infinitely more complicated around flow lines. But again, certainly can be part of the conversation, probably is part of the conversation.
Okay, can you explain to me what the notice to operators, what I guess power or legal backing do you have to enforce violations, I guess is the right term, for companies who aren't compliant with it?
Very good question, to which I will now turn to my attorney. No, there are legal implications, surely. And there are parts, I guess I feel fairly comfortable saying that a recalcitrant operator who said, show me the rule that says I have to do that, there are probably parts of what we've asked for them to do that I would have a hard time pointing to the rule. If we get there, then you'll be asked to re-engage, I think, and there are different ways we could solve that, short of rulemaking, I think. But I think I think it's good for you to ask the question, and I think it's good for you to understand that there are parts of what we're asking them to do that are, essentially voluntary compliance. And if they dig their heels in, if anybody, and says, you can't make me, we'll come back and ask you to think about ways that maybe it could become a mandatory requirement, or that has the enforcement of penalties that could be imposed for failure to comply.
Commissioner Jolly?
Yes, on this NTO, and I've done amazing work to get that many wells inspected in that length of time. But does the NTO just cover the approximately 15,000 wells that you've identified? To take it to the next step, there's around 60,000 wells in Colorado.
54, 55.
Are we eventually going to check the flow lines at all these wells, or is that necessary in your opinion to expand this once we kind of catch our breath?
Well, I think, again, Commissioner, I think there are two parts to the NTO. One that does have the 1,000-foot within a building unit constraint, and the other that does not. And the part that does not are the abandoned risers. And so that abandoned riser requirement goes statewide, no matter your proximity to a building unit. And I think that should be enforced. I think that should happen. Now, I have to tell you, there's one variation on that I'll explain in a second. But for the most part, I believe that not allowing abandoned risers to remain in place above ground reduces the risk of a repeat occurrence. And I think we should have that happen. And that's statewide, and that's every well. So after June 30th, if we're in the middle of, north of us here, which there's not a whole lot of population around.
Exactly.
And there's an abandoned riser coming up out of the ground that's not being used, it should be cut off below grade. So since Commissioner Agar asked the question earlier, if I tell the operator you're out of compliance with the NTO, you have to cut it off, that's one of those places that it's not so clear legally, because that's a retroactive application of a rule that took effect in 2001, assuming they abandoned that line prior to 2001. But that's not the right answer to me. It's legally correct answer, it's just not the right answer. And that might be a situation where we would come back and ask the commission for an order or something like that. And again, the flow lines are supposed to be tested annually as it is. So let's get that done, right? That's more of an enforcement compliance of existing in-place rules. I think we have the tools we need to do that. I mean, maybe, I can always say I could use more resources. So I'll say that. I could use more resources. But the legal structure is there. And beyond that, no, I don't think this is a systemic or endemic situation that we have, lots of holes to plug.
To date, it ties a bit with what Commissioner Hager asked. The notice that you sent out to the operators, obviously nobody's going to come back and say, I refuse to do this. But have you any sense that you haven't had any operator that really has come back or just said, I don't want to do this, I don't have to do this because you can't make me?
I don't think we've had the you can't make me conversation yet. We have a pretty sizable number of operators that have one or two wells, literally, that's how many wells they operate, that aren't real plugged into our processes at any level, including COGA or other things. So we're kind of reaching out and hand-holding and saying, this is what's required. So that, there's a little more time involved there. I think that's sort of the big one. And then I said there was one exception to this that we should probably talk about. To me, one of the most important contributing factors here is the distance between the well and the tank battery, right? So you had some span of 3/4 of a mile or something. And that's not uncommon. It's also not the most common scenario. The most common scenario is the well is there and the tank battery is 75 feet or more, 200 feet away, but it's on the same pad. So on the same pad, if I have some of those older abandoned risers, and I know that point A is here and point B is here, and my plan is to abandon that location in the not too distant future, do I really have to cut the risers off today? When my standard practice is it remove the entire flow line, risers and all, when I abandon that location. So that is a very specific question that has been asked by two different fairly sizable operators. And I think it's a fair question. I mean, it's, the risk, nobody's going to build a house on top of that flow line. So there's certainly a mitigating factor just by terms of the short run of that flow line and the distance between them and the fact that you're not going to build an occupied structure on top of it.
I guess maybe I missed something, but it would seem like with that, in that particular case, if you have, say that's point A to point B is just across the location, a fairly short distance, if the line is plugged on both ends and pressure tested, and you more or less have complied with the NTO, is that correct? Even if you say I'm not going to use it, I plugged it, I pressure tested it, if I'm going to abandon it when I abandon this facility and restore the location.
Well, I'll answer a little bit differently, Commissioner. I think if we want to entertain that variance to the NTO, I think requiring a pressure test would be an important step. That's actually not part of the abandoned riser part of the NTO, right? So it's coming up over here. It's not in use. It hasn't been in use. We're not going to put it back in use. And so having them identify that it ends over here and pressure testing it would be an important point. Because one of the things that happened here, remember, is that there was a T in the line.
Right.
So really, are you sure that that's point A and that's point B and there's not a point C? And pressure testing it would at least tell you that even if there's a C, there's integrity there.
Right.
And then I think I would advocate for some notification type documentation so that if the change is hands, everybody knows. There are things we could do if we're gonna entertain that variance. There are things we could do to make it a little more robust than how it was written in the NTO, which anticipates that things go away.
So ultimately, but it's maybe a case that you need to use it. Maybe much like wells that you periodically have to have a mechanical integrity test done on them. Do you do something like that with flow lines?
Yeah, good thought.
Possibly.
Thank you. You're welcome. Thank you. Anything else with this matter? We're a bit off schedule. But I think next on the agenda is to report on the Orphan and Distressed Operator Program.
Thank you. Again, I'm Dave Andrews out of the Rifle Office. Just to give you a little bit more background on our Orphan Well program and I guess my status with that program. When I started working with the commission in 2006, I came in as a staff engineer in Wattenberg. And after about a year, there was a vacancy for the engineering supervisor position for the Northeast. I ended up getting that position, and as part of that position was managing the orphan program at the time, which when I came into that, I was essentially given a stack of paper about this high and saying, that's our orphan program. So one of the first tasks was really to organize that data. So that involved creating a database with that data, creating a compared to what we have right now, more of a crude prioritization system, which looked at a few different factors on how and when do we go and abandon certain orphan wells. So prior to the orphan system, we claimed bonds from operators going back decades, probably back to when the commission was originally formed. And just a little bit more on my background. I have a background in environmental investigations, remediation, and then I've been essentially working as a petroleum engineer, first over on the Front Range in the Northeast. And then in 2009, I moved over to the Rifle Office. And at that point, we had reorganized. Prior to that, the field inspectors were under the engineering group. So I had experience, managing our field inspectors and understanding what they were seeing in the field. At that point in time, that group broke off, and we reorganized the engineering region so that I was supervising the engineers in the Northwest and the Southwest. So I've had experience across most of the state, and some experience with downhole as well as environmental remediation. And I'm licensed as an engineer in Colorado, Michigan, and Wyoming, and a geologist in Wyoming. So moving on a little bit, and if you don't mind, I'm gonna rotate this because I don't want to get whiplash like it looked like we're getting. Okay, so today we'll talk about both orphan wells and distressed operators. So again, in the past, we just generically use the word bond claim for distressed operators. The new phrase kind of came into play probably a couple of years ago. So as a programmer overall, now we've shortened it to ODO. We are a government agency, so we need an acronym for it. So looking back, and a few of these slides in the beginning really focus more on the northwest part of the state. This presentation, or a part of it, I originally gave to Garfield County at the Energy and Environment Symposium back on April 19th. So this well in particular was one of the wells that we plugged near Debec. It was originally drilled as an oil and gas well. It went to an old homestead that connected to a cistern. So We think they may have been getting both water and gas out of this well at some point in time. And the photos dated back to around 1905, 1910, that type of time frame. So drilling on the west slope began in the early 1900s after natural gas was discovered in northwest Colorado. The reference I found for 1890, they didn't really specify which field it was, but somewhere in the area over here. COGCC was established in 1951, and part of the initial regulatory authority was for regulation of groundwater or protection of groundwater, and plugging and abandonment began the same year as far as the requirements for plugging wells. Statutory authority comes from 346124, which is shown here, and much of it revolves around protection of the environment. So when we're plugging wells, we have to take a close look at the geology, isolation of the hydrocarbons, and groundwater resources. So we get funding through both bonds that are claimed from operators, the distressed operators portion, as well as an annual budget of $445,000. So when I originally managed the program back in 2007, for about a year, we had, I believe it was $220,000 a year, and around, I'm going to say 2012 or so, the commission approved an increase in that budget in some respect to look more at reclamation of certain locations. We had the reclamation rules change around 2009, which made it more stringent than what we had a few years before that.
Dave, can I interject for a second?
Yes.
So just keep in mind that the 445 that Dave mentioned is an allocation by the legislature, so that they have to do that every year, and they have consistently. They could raise it, they could lower it, they could make it go away, but we are dependent on them for putting that line item in that, you know, $445,000 goes to this program.
Thanks, Matt. So I guess to that end, when we have a bond claim, ordinarily we will run through the bond monies first.
You have been conducting a meeting for a long period of time. If you need to continue, press 1 now. If not, I'll end the meeting.
Okay, so we would run through the bond claim portion for any operator that either went bankrupt or we claimed the bond for other reasons. And once that money is exhausted, we would go dip into the 445 orphan appropriation.
Can I ask you a question about that?
Yes.
So I saw in the two of the enforcement matters that we dealt with this morning, the bonds, the bond was $1,000 and another one it was $1,500. What's the average cost to actually go through the process of plugging and abandoning one of these wells, and how much is the delta, I guess, that people of Colorado are paying for?
It depends on a variety of factors. One of the big factors is how deep is the well or how deep is the plug back. And in some case, we may even need to drill out existing plugs if there's gas leaks around those plugs. So that's a large factor. Another large factor is related to the location, whether or not that's built into a slope, as we have many locations here in the West Slope, versus a location out in agricultural field, let's say out on the Eastern Plains, where we may not need to, for one, contour, and secondly, vegetate that location or establish vegetation if it's if the landowner wants to use that as a crop field. So those are two big factors. Another factor is whether or not we need to remove surface equipment. Oftentimes we don't get much for salvage value. If anything, a lot of times it turns into a disposal cost as opposed to salvage for equipment.
So just as a general rule of thumb, recognizing that there are lots of,
cost.
like 10,000, 5,000?
So for average plugging costs, we're usually somewhere in the range of 25 to 50,000. And then reclamation would be on top of that for a typical well location.
Mr. Chairman, may I? Dave, are you going to talk about the current bond requirements? If you, I will briefly if you.
Do not have a slide for that.
Okay.
Go ahead.
So Commissioner Overturf, the 1,000 and 1,500 were, well, I don't know if they were under an old regime or if they were bond on scenarios, but here's the current, let me tell you the current bonding requirements, okay? For a deep well, deeper than 3,000 feet, it is $20,000 per well, okay? So that's the bonding requirement. And now you sort of have some least ballpark figure of what it costs to really plug a well, okay? So it gets trickier because we have something called blanket bonds. And most states that do a bonding program, a financial assurance program, also have blanket bonds. In Colorado, you pay $20,000 for each of wells numbers 1, 2, and 3. After 3 wells, you can have a $60,000 blanket bond for anywhere between 4 and 99 wells. So sort of nightmare scenario for us is an operator with, let's say 30 or 40 wells and a $60,000 bond. That doesn't make it financially. Then you get to the next level, you have 100 wells and our blanket bond is 100,000. And, you know, part of the rationale here is that somebody that has 100 wells probably has pretty good capital resources. You're a little less worried that they're maybe the less likely candidate to suffer catastrophic financial loss compared to that operator with 20 or 30 or something. But this is a huge part of why we have the $445,000, why Dave is spending a tremendous amount of his time managing these distressed operator wells and orphaned wells. And we've had some conversations with industry and with legislatures. We actually ran a bill. Well, we didn't get it introduced. I guess we had discussions about a bill that would give us some other potential revenue sources when we get into these distressed operator scenarios to make it easier to sell some of this equipment and things like that to augment that bonding a little bit. But there you go. So the 1,000 and 1,500 are small by current standards, and the 10,000, 60,000, 100,000 are inadequate if what your goal is to have enough of a financial assurance to plug and abandon every well that an operator has that they might walk away from.
And I would say much of that argument came into play in 2009 during the bond rulemaking, where we ended up increasing the individual well bonds, but I don't think the blanket bonds moved at that point.
Question, but when you say deep well, are you talking about horizontal wells too?
Yeah, the same bonding applies to horizontal wells.
Anything over 3,000 feet in sort of
3,000
total
feet.
length.
Yeah.
Counts as that. So I think one of the other things to keep in mind also with particularly larger companies is that they have an ARO account, which is set up internally for their financial obligations to abandon wells. So again, it goes back to what you said is, you know, once you get it over a certain size as an operator, you've set aside a financial obligation to plug and abandon your wells. So that does provide the state with some level of comfort in that respect as well. It's that I think your nightmare situation is the one that was the operator with 30 wells. So go ahead.
Just was going to add, I forget what the exactly what the rule is on that, but don't we increase the bonding for excess inactive wells, which is just a higher level of risk if you've got wells that aren't producing?
Yeah, thank you, Commissioner Hawkins. That's a very good point. So under Rule 707, we do have the authority to require additional financial assurance for an operator whose shut-in or temporarily abandoned wells start to outnumber $20,000 times the number of shut-in wells. That makes sense. It's hard. It's hard. This is such a hard concept to explain in a simple way. I have $60,000 of your money in a financial assurance account, theory being that that's sufficient for 3 wells. If you have if you have 4 wells shut in, I can come to you and say, I need $20,000 for that shut in number 4 and 5 and 6, et cetera, if they're shut in. And that is a way, if it's not too late already, that we can get additional financial assurance. And we have used that tool aggressively. Martha Ramos, who is our supervisor for financial assurance, has been great, and Stuart and the engineering group have come up with sort of a matrix of worrisome factors that we, can start to reach out to these operators earlier, proactively, and say, hey, guess what? You're under bonded. And we've brought in a lot of additional financial assurance through that mechanism. But it does run the risk that it's too little too late.
All right, and just back to the bottom of the slide here, the orphan fund was originally established in 1990. So prior to that, any work, I guess, under the program would have been just bond claims. So we work collaboratively with the COGCC. They have a publication, at least the last time I saw it, I think it was coming out about every 5 years or so. So we do contribute information to that publication, and they maintain some statistics on orphan wells in the oil and gas producing states. And Matt already mentioned our 700 series rules. So what that really covers under the basic bonds would include the surface owner protection bond. So we may have a bond available for that when we go through a bond claim. That's for unreasonable damage to land or crops. The primary bond for the wells that Matt was describing is for soil protection and plugging and abandonment. And then again, excess and inactive wells. So one thing that comes to play in the second item there is any environmental impact that may be existing at a tank battery. So removal of that equipment, cleanup of any soil or groundwater contamination would also fall under that. So going back historically a little bit prior to calendar year 2017, our prioritization database for orphan wells mostly looked at leaking wells, complaints, and bond claims or distressed operators. And during the prior talk, Director Lepore also mentioned the study that was performed a few years ago on what are the factors that are involved with most of the spills. So this comes from that study itself, looking at the percentages of factors for various issues that contributed to spills. So carrying forward to changes with the orphan program, we wanted to take some of those factors into account. So we are now looking at population density, environmental risk, and years in service. And this comes directly out of the same database or the matrix that are used for the field inspections and prioritizing inspections of those locations. So I think it was January 4th when Director Lepore and the managers asked me to attend a meeting and essentially asked me if I'd be willing to kind of revamp, take the lead on this program, and really try to incorporate some of the goals that were established during the lean event last fall for improving the orphan program. So as part of that, we really looked at changes in the organization. One of the goals of the program was to create more of an interdisciplinary team where we had members of engineering, environmental, field inspection, and reclamation all kind of working together to look at all these sites to make sure that we're looking at all the factors, not just, plugging the well. As part of that, we're developing a new reporting structure, and that helps with both internal and external communication. And again, looking at shared responsibility between the team members, and also developing some new project management procedures and work specifications. So the implementation plan, again, the process improvement was last fall. I was not personally involved in that, but I was essentially given the deliverables and said, okay, we need to develop a program around this. So that was the initial, I guess, charge. So on November 1st, the lean deliverables were completed, or the process improvement deliverables. On January 1st, or I guess it was actually January 4th, we began selection of the new orphan well team. March 1st was the plan to secure new project management software, which I ended up going a little bit different direction. I'll explain that in a little bit. But also have project management training available for that core team. April 1st, the orphan well team review and prioritization of existing projects, cleanup of old projects. That was the target date for that work. And then also starting to track new projects with the new prioritization criteria. So the eventual goal was to have the new process available and fully implemented by July 1st, and we are on track for next fiscal year to have projects scheduled based on that new prioritization. All right, so this is the new structure. So in the past, we've had a program lead ever since I've been here, but everything else is somewhat new. So the unit supervisors and managers, that would be the environmental unit, the engineering unit, they until now reported just directly, up the chain to their unit supervisors or unit managers. And it was kind of up to the program lead for orphans and distressed operators to reach out to those units without necessarily having the authority to have those staff work for that, the program lead. So a big change in this structure is essentially giving the program lead some authority to work with those staff from other units on like a temporary work assignment. So the program lead would then work with individuals appointed in each of those units, and also have some authority to direct some of the staff in the support positions. So a lot of this goes beyond the technical units. We have Jeremy Farron over here. He represents our hearings unit, and he's been on a lot of the conversations and the weekly meetings. We have people from financial and other support positions that kind of help out the whole program. So once we get to a point of actually working on a project, that's broken out by task size or project size. So we may have a project leader and individual task leaders. It really depends on the size of that individual project. So as part of this, again, we're trying to implement some project management and support tools. So after looking at some project management software, part of the charge was use a system that doesn't cost us anything. So we had Google Suite available. So I started looking at some of the tools available with Google, with their forms or spreadsheets, how everything kind of interconnects, and that's the direction we decided to go. So just looking at overall time put into this program since January 4th, we are over 1,000 hours each day and each week. All the staff working on the program will submit data to me on their work on that given week. Just the photos of some plugging operation. Sometimes we need to deal with salvage and junk equipment. This is looking at reclamation before and after, some of the tools used down in the bottom there. Okay, so another part of this program is getting staff involved and getting staff excited about it, about doing this work. So one of the tools was trying to collect information from staff on ranking their own qualifications. So we have, engineers working on these projects, environmental specialists, reclamation specialists. Everyone has kind of a different skill set. So I wanted to collect data on our internal staff on who would be qualified to do which type of work. Those are just the results from those surveys. Looking at the different type of financial surety that's available. Right now, as far as all of the new projects that we've been putting in this year into the new system, the majority have been individual bond claims, but we do have a large percentage of blanket bond claims, and then would come the excess and active. As far as bond type, most of the funds come from plugging bonds, followed by, looks like, gas facility, and then surface. And we had one operator with a bankruptcy deposit. For discovery of these projects, many of them come out of enforcement when we end up claiming bonds, but we also get a significant portion from field inspections. So that would be just routine field inspections. Our inspectors looking for historical IDs of wells, trying to get that information into the system. And then we have a few other sources. For project types, this only applies to the 52 individual projects that have been entered in the new system this year. So the majority right now are orphan, but the percentage of distressed operators continue to increase. We're trying to track things by task as opposed to project now. So an individual project may have multiple tasks. Ordinarily, that would include at least plugging and abandonment as the first task and then reclamation as the second. But we have some projects that, get broken into 10, 15 tasks, which may have multiple locations. Okay, going back to some of the risk factors that we're using in the new prioritization, we do look at population density and urbanization. So you'll see that that kind of falls into 3 and 4, which would be more dense population centers. Environmental factors would look at things like proximity to surface water, whether or not there's a designated aquifer in the area, that type of thing. And then we also look through the field inspections for each location on whether or not there have been any reported spills or any spills noted in the field inspections. Fortunately, at least for the ones that we've entered so far this year, most of them end up with no known spills. Okay, then we look at stormwater. What is the proximity to surface water? Is there any evidence of off-site migration of sediment? Is there any surface equipment to remove? And if so, does it have any fluids in it? Mechanical integrity test. We go through the MIT records to see if they are current or if there are known failures of the casing strings. We often have FLIR inspections now, so we look in the FLIR section of the field inspection reports to see if we have any known gas leaks or any visible liquid leaks from the wells. We're looking at whether or not there's a stopgap measure. Can you turn a valve to stop a leak? Is there something that we can do quickly to get out there and lessen the potential for impact? How complex is the task? We have one this current fiscal year. We're trying to get it done this fiscal year where we needed an Army Corps permit for wetland. So that has been a complicating factor. So certain things require a lot more effort just to get the project going. We're looking at access. Sometimes we need to improve roads, sometimes build roads in order to get into the well locations to plug these wells. How long has it been on the orphan list? So even if it may be a low environmental priority, we don't want these projects out there 20, 30 years either.
Why were so many added in 2016? Somebody was just really paying attention that day?
A lot of that comes down to the bond claims. So the older, I mean, ideally you don't want to see anything on the older side of the scale because, you know, we want to get these projects done as they come in. But there were many wells and many locations added with bond claims in 2016. Okay, here's a quick example of site access. This is one where these wells were drilled around 1902 to 1905. There's a well that was located here off to the right and one up to the upper left. We retained a civil engineer to design an access, gravel access road to get into those locations to plug them. We also had to divert some existing irrigation, install stormwater BMPs, fences. It was a horse pasture. So a variety of concerns for that particular location. So this is what it looked like with the wells before we moved in to plug them. We had one leaking gas well here, one well leaking fluids here. And that was after constructing the road, constructing the pads in order to plug those wells. And this just progresses through a typical plugging job where we start out with a shut-in well, move in to plug the well. That's our reclamation crew moving in to perform that work after the well's plugged. And, well, follow-up inspections would occur for probably months or maybe a couple of years until we know that the vegetation's established. So moving forward, really starting this week, it's wrapping up the fiscal year 2017 projects by June 30th. We have multiple projects occurring right now. Reconciling the accounting for those projects and then generating the list for fiscal year 2018. So anyone that's been looking at this at the staff report probably has noticed that that content has not changed too much in the last few months. The goal is to try and get that done for the next staff report. One big stumbling block that got in the way was the situation in Quebec. So that's really why you don't have a current update on the staff report right now. And with that, I'm open for any other questions. Yes. Oh.
How many orphaned wells do you think we have coming down the pike here in the next 3 to 5 years?
At this point, with the bond claims that have rolled in over the last few years, we don't have all of those registered the new system, but I mean, we're looking at hundreds of locations.
And we have budget for not even dozens of wells, it would appear.
Right. So for the annual budget of 445, you know, not every well is going to be in the 25 to 50 range. Some of them are lower dollar amounts. I usually think about 25 because that's our purchasing limitation where we need to start bidding. But between plugging and reclamation, it is a sizable amount. So really shifting from the end of this fiscal year where we're concentrating on trying to get some of these orphan dollar projects moving, the next step is really to take another look at the bond claims and where those all come into play. An example is the bond claim for Texas T with wells that are in the Brighton, city of Brighton watershed, or not watershed, but surface water protection zone. So that work has been bid out. We were trying to get that in towards the end of the fiscal year. It's not going to start until the first week of July. So we're going to have kind of a large chunk of bond claim, and then that will roll into orphan money beginning in July. So it really is a difficult thing to do, to try and look at all of these different factors that go into the prioritization, whether it's coming from bond money, whether it's coming from orphan money, and trying to fit that all together so that we're spending what we need to in any given fiscal year.
Well, with the program that you're instigating here or starting here, is there some way to look down the road and try to work with these operators earlier or more aggressively than when it's obvious they're they have run out of resources?
It's an interesting question, because most of the time, once it reaches my desk, we've already been through the bond claim process. Certainly, we have inspectors out there trying to work with these operators to get them into compliance. But the biggest stumbling block that we've run into the last few years has just been the crash in oil prices. I mean, that's where we've ended up getting a lot of the bond claims coming in for not just 1 or 2 wells, but 20 wells, 30 wells, 40 wells. So that's really why we're seeing that number kind of spike up around 2015, 2016.
It looks to me like we have quite a wave of them coming at us.
Yes, we do. And I mean, that's why it really makes it important to prioritize and look at not just, getting with every supervisor of every unit, which is often what we used to do, and say, which one is on the top of your radar screen, but really looking at each one quantitatively, using all of our factors. We end up adding those up into a score, and then we've got some other soft factors that go into it, but trying to address the ones that are really the problems first.
What do we do to prepare ourselves for monetarily for what's coming our way? Is there huge pushback from industry to increase bonds? Is that one of the issues at hand, or?
There was in 2009.
I think that short answer is yes. Industry, especially smaller operators, tell us they don't have access to surety financing. That it's essentially requires them to put up their own cash 100% for the bond requirement amount. We have had presentations to us by surety bankers at the COGCC, the Legal and Regulatory Committee that I was chairing at the time. We had a presentation from surety bankers. It's like any other risk assessment, right? I mean, they're looking at your assets and your risks and your liabilities, and they look at that for a small operator and say, you don't got much I want, so you're, that's, none of that's to say that, I mean, it keeps us awake at night too.
What are our bond levels like in comparison to other states?
I personally haven't reviewed that in years. I don't know if we've had anyone look at that recently.
Well, I can speak to that. So again, through the COGCC, the Legal and Regulatory Committee did do a survey, and I don't know if I can easily give you a general characterization. Blanket bonds are common. Most states have the same concerns we do. Most states, individual well bond is probably insufficient to plug and abandon certainly a more complicated well. But many states do have higher blanket bond amounts than we do. And some states have gone to bonding based on a price per foot of depth. So there's a different model of how you calculate the bond. And I would actually probably be best served to direct your attention to that report rather than try to characterize it myself. Again, most states follow a pretty similar model. I would say many states have a little more, there are many states whose blanket bonds exceed ours. There are a few states, including Oklahoma, that have a separate funded pool of money for plugging and abandoning wells. And really out of we probably surveyed 35, 36 states in this IOGCC survey. And about 3 or 4 of them have this separate pool available. And there's different ways to fund that pool. In Oklahoma, it is funded by a voluntary, and I'm using air quotes for those on the radio who can't see, voluntary contribution by the industry that goes to a third party called the Oklahoma Energy Resources Board. And OERB uses that money for 2 things, and I don't know the proportions between the 2 things. One thing is to plug and abandon orphan wells, and the second is education around oil and gas, fossil fuel development. And I think it's like a 70-30 split, roughly between 70% for plugging wells and 30% for education. But be that as it may, that's how they fund that. One beauty of the OERB model is that it's out of reach of the legislature. It can't be rated, if you will, in lean times, because they created this quasi-governmental third-party entity to whom that money goes directly. And that is a model that we have had conversations with industry about, and that has actually surfaced a little bit in the what happens after Firestone conversations, because there is a need there. So that's one model.
So one other thing I'd like to mention is, performing these projects and trying to get them prioritized, it requires a lot of resources. I mean, you saw it with the staff hours, and even at our 445 right now, plus the bonds that we ordinarily spend in any given year, puts a lot of stress on our staff resources to get that work done. We do have to go through the bidding process through DNR. We do have to have full-time on-site supervision of the work to make sure it's being done to the specifications, and along with all the follow-up that goes along with that. So, just saying, well, we need to spend more, that's one thing, but having the staff resources to actually, make that happen, that's another part of it.
I'll put one of the concerns, obviously, is that if you raise a bond, the same issue you come up with is the operator will just say, here, take my wells because I can't cover the bond. So then you're stuck in the same box, essentially, is the issue. I was just curious about, and Commissioner Jolly mentioned how many wells currently does the state more or less operate?
Well, 0, because we cannot operate wells.
Okay.
We've had that question from surface owners with orphan wells on their property. In one case I can think of, that was also the mineral owner, or they had some mineral rights. So they asked the question, well, why can't the state just produce this well and give me my check? Or
yeah, we can't be an operator, right, but you're sort of de facto when it becomes an orphan well, you're de facto.
So yes, right now we're working through the transition from the old database to the new registry with the prioritization system. But we're certainly looking at hundreds of locations at this point.
And a corollary to that, sort of tied back to Firestone, is that do we have some program on these wells to look at them for risers?
Right. So the flow line issues, we kind of consider ourselves an operator for some of them, because if it's a true orphan well where we don't know who the operator was to begin with, we assign it the commission's number, operator number. So we did go through the list of wells listed as the commission for operator, the unknowns. We've got like 3 categories: commission, unknown, and unknown operator, which we should probably combine. But we made it through nearly all of those, and the last group, those are kind of in the process right now of prioritization. So we're, working through those the same way an operator would work through their wells.
Okay, thank you. I was a little bit worried about that because that is a big concern that they're orphan wells. You also have those lines that are associated with those. So, all right. Yeah, and hopefully I didn't take anybody else's time up if you had any other questions. All right. Okay. Thank you.
Okay. Thank you
very much. So it's a bit before 3. Would anyone like to take a quick break before we move on to the next item, or should we just continue on? We have the enforcement hearing and then commissioner orientation. Yes.
So, Mr. Chairman, point of clarification, the energy search matter is probably a 10 to 15 minute matter. And then I think there's been a motion, maybe not officially seconded yet, that the new commissioner orientation be postponed. Because seconded. All in favor? So I think you have 15 minutes left on the to wrap this up.
I would say let's continue on and wrap this up.
Oh, I lost the chairman, so.
Sorry.
Oops. That's okay. I'll get it.
So I got to change this. It's no longer morning. Good afternoon. 1706-00310, which is an enforcement proceeding against Energy Search Company. This is going to dovetail pretty nicely with Dave's presentation because this is a distressed operator who is about to become somebody, if the order is approved, that will enter Dave's program. So I'd like to note for the record that there's no one here on Energy Search's behalf. Energy Search has completely failed to participate in these proceedings despite numerous opportunities. So commissioners, this is another operator that's failed to live up to its regulatory obligation despite multiple attempts by staff to get them into compliance. They've been non-responsive now for a couple years and so have effectively abandoned their wells and facilities, and staff believes it's time to revoke their right to operate in the state of Colorado.
Oh. Oh,
So by way of background, 2014, the commission entered Order 1V490, which imposed a penalty, ordered compliance for a number of rules that Energy Search had failed to comply with. To date, Energy Search has not complied with that order. Fast forward to 2015, different order, different violations. This is actually Rule 707, which is the inactive well bonding situation where for this operator it was too late. The order penalized them 60 grand for the violation and then ordered them to post $160,000 in additional financial assurance, which of course they were unable to do. So like I said, this was an operator where it was too late. So fast forward to 2017, we issue an NOAV for those two violations, for the violation of those two prior orders. And then we also took a look at their compliance with Rule 326, which is the mechanical integrity testing requirement, and found that they were non-compliant at essentially all their wells, so 14 wells. And I think that is indicative of a distressed operator. With time, your wells are inactive. They will eventually appear on the MIT query that we run, and they will become a subject of an enforcement action. I will say we held off on energy search for a bit, and the reason why was the surface owner was plugging some of their wells for us before it was our obligation. So the surface owner was doing it because these are Adams County wells, and he wants to build a neighborhood, and it's easier if there's no wells there. So we would have come to you sooner, but the surface owner was plugging those wells, and it's 2 or 3 fewer wells that we'll have to take care of.
Did I understand right? You're building a subdivision there?
Yeah. So in order to make it easier to subdivide the surface, he took it upon himself to plug the wells, I assume abandon the flow lines, get rid of the surface equipment, and
Does he do it to
increase the value of the surface?
No, to COGCC standards?
Yes.
I mean, you guys oversaw how he did
So,
it?
yeah, so the way it worked was, because energy search was still I'm using air quotes, operator, they had a bond, they had a operator number. The surface owner, in consultation with contractors, was able to, file the documentation necessary to plug those wells. We would approve it. They were plugged up to our standards, and now they're plugged and no longer an issue once this enforcement order is entered. So moving on. As I noted, Energy Search has not responded to the NOAV. They didn't appear at a pre-hearing conference. They haven't filed anything. They haven't objected to staff's filings, and they're not here today. So in front of you is essentially an unopposed order, which is located at Bates page 312, if you're interested in looking at it. We're asking that you find a violation of both rules 522 and 326. We're asking that you impose a substantial penalty, and that penalty calculation is in front of you. It's essentially $1.2 million. And that's just the math that comes out of the rules and the policy. Plug in the dates, do the calculation, that's what comes out. And with no operator to make a counter argument, we don't see any need to adjust that. So that's the penalty. We're asking for an order that requires Energy Search to return to compliance. We have no expectation that they will. So the meat of the order really is the second part, which is if they fail to comply or when they fail to comply, staff will be authorized to do a number of things. Some of the things I'm highlighting here: declare the wells orphan, then go into Dave's program, revoke their right to operate. So we have no expectation the surface owner wants to do any more plugging activity for us. So it's time to just pull their right to operate. So
Can I ask a question about this
Sure.
part? I've thought a lot about under what circumstances it would feel appropriate for you to exercise this discretion and not revoke their authorization to conduct operations in Colorado. And I'm having a really hard time coming up with one. And I'm wondering why this is left to staff's discretion and why we're not just saying it will be revoked.
there's no automatic mechanism for that to happen.
I'm just wondering, are we saying that this is something that that the director may but is not required to take these following actions? Is there a reason why we're saying may instead of will, shall?
I think part of it is the 35-day appeal deadline in the APA. So this final order could be appealed. If it was appealed, perhaps the director would not exercise that discretion, but I don't see anything that's going to stop us in 36 days from exercising that discretion.
Does that answer the question?
It does answer the question. I still
Essentially,
would rather it say that you're.
Well, I think the Administrative Procedures Act mandates that we have we have to give them 35 days. Is that correct?
Yeah, I don't think there's any way around.
So
appeal, but not to, that doesn't, I mean, it could be that you don't revoke it for 35 days.
And that's the way it's structured.
Yeah. That's what you're saying you're going to do.
Yeah, if they do nothing, then it's day 36, you're done. So there isn't any may, I don't believe. Go ahead.
Well, no, it
Director.
still says the director is authorized but not required to take any or all of the following actions.
Go
after
ahead,
35
Director
days.
would help me out here.
Well, I think it could easily be drafted around to address Commissioner Overturf's question. I mean, you could say after the 35-day right to appeal expires, the director shall do this.
it just seems like a particularly egregious case of failing to even engage in this process.
And I don't have any objection to tweaking the language as we sit here today, if you would prefer that. I think what we do want the discretionary language in is all of those other subparts where we say we're going to claim equipment, we're going to plug wells, we're going to do X, Y, and Z, because that definitely requires our discretion and needs to be plugged into Dave's program. So, I mean, we can't, or we would prefer not to obligate ourselves to do that immediately. And I think one of the other concerns was maybe a federal well is involved and we've got to coordinate with BLM and those sorts of things. So if you want the revocation language changed to shall, I don't think we would object, but all the other subparts, I think we would prefer to keep that discretion.
There's a little bit of boilerplate language going on here. I mean, this is pretty standardized for this scenario, and not everyone will implicate every single one of those discretionary actions that you are contemplating bestowing on me. But yeah, I think easy to draft around that particular concern for revoking their right to operate, or whatever the language is.
Is there any reason to think there's any of the Roebuck plans still around, or with an interest in other companies in the state?
To my knowledge, no. So the Roebucks, it was the father and the son. The father kind of walked away. The son had tried to get the company across the finish line, was unsuccessful. And so that's the non-standard section, requiring the principals to notify us if they want to operate again in the state of Colorado. And if they do, we wouldn't approve their new operations administratively. It would come before you guys. And that was an attempt to sort of deal with piercing the corporate veil. And we had some instruction from the commission that they wanted to hold people individually liable. And council said, it's kind of touchy. Let's do this instead. So that's the non-standard section of this order, but it has appeared in, I want to say, pretty close to 10 orders at this point.
Can I say?
Certainly.
Next question. This is really, when I commented earlier today about these orphan wells, it was really this proceeding that I had in mind. It's obviously an egregious situation where they're essentially walking away, turning the wells over to the state, saying it's your problem. And we end up assuming the problem. We'll plug the wells at our cost, and there's no further recourse against these people. So my question is, have we explored, and I think Director Lepore's answer is you really haven't had don't have the resources to go after people like this, but where do they live? What state do they live? Are they operating wells in other states? Can you be in touch with the agency that regulates oil and gas in those states to put them on notice of what they've done here? Maybe put some pressure on, or at least keep them from doing the same thing there. Should we be hiring some sort of a private investigator to search out who they are and where they have assets, and see whether there's some sort of potential civil liability that can be enforced against them? The idea that they can just simply walk away, to me, is offensive. And I would like us to see whether there's some more aggressive posture we can take. It may be that we'll need a specific appropriation or resources in some way to add this to your portfolio, but I just don't see why we should be left holding the bag.
So
just a brief comment. Then, in the time that I've served on this commission, that's something we have continuously struggled with, as to how do you go after these folks that have essentially left this problem, and it's an expensive problem from the state to have to take care of with little or no funds.
Well, and the other point I made earlier was the possibility that there are other working interest owners in the well who could have some responsibility.
May I, Mr. Chairman?
Certainly.
A couple of thoughts. first, again, I think it's all good for us to take under consideration and advisement. I like the idea of communication with other states because we do have a channel for doing that through the IOGCC. I think some of what you touched on, Commissioner, probably gets us awfully close to that piercing the corporate veil part, and that's a large undertaking that, for example, I think would, from the get-go, and in this proceeding, for example, require notice to those individuals that something like that was being contemplated, that not only might the commission impose penalties and so forth on the entity, but that we intend to seek, some kind of individual liability. Those get tricky. I do want you to understand that I think we are more aggressive today than ever before, that this has been an evolution, that I can trace back the language there about requiring principals to notify staff if they want to operate other wells under another name. I think I can take credit for something that initiated or happened when I was the assistant AG with, again, a pretty egregious operator who he said, okay, we can't pierce the corporate veil, but we don't ever have to give these people another permit to operate in the state. And we think we're walking a fine line between piercing the corporate veil and exercising jurisdiction or authority that's clearly yours. And the number of these that I think Jeremy referenced, maybe 10 of these with the orders of this language, those are all in the last 4 years, maybe 5.
Certainly during my 3 years here, that's gone up. And I think Dave's slide where it went up in 2016, that's why these sorts of actions.
But in any event, that doesn't mean that our work is done or there aren't other avenues to continue to explore, and I appreciate those suggestions. The working interest owner is one that we just haven't been very mindful of, I think, it's fair to say, and maybe, I think we need some legal guidance there. But if they're potentially liable and they've got money, I'd be happy to go issue. I'd be happy to recommend that you issue an order that they are obligated for those penalties.
I'll just point out the obvious. Energy Search itself could be an operator in any of these other states. You don't even necessarily have to pierce the corporate veil, although it's fair to say they're bad actors in terms of our statutory authority. So I personally would have no problem in characterizing them as the principals of this organization. As such, let the burden be on them to justify receiving the privilege of operating in the state again through any other entity.
Right. Well, and the other thing that we can tell you from experience is that those individuals, and I don't know their names, you mentioned them, they could operate under a different name in a different state. And that's what we really see. We see those same people coming back into Colorado under a different entity. And we've figured that out too.
And sorry, I wanted to mention there is a procedure for uncollected penalties to be handed over to the AG's office and then go through collections. It's a black hole as far as I know. It's a process, but I don't know that we've ever seen funds come out of the black hole. So we're hopeful. So we're also asking you to find a couple aggravating factors. The first, recalcitrance and uncooperative. Their non-appearance here today and through the proceeding, I think, is pretty strong evidence of being uncooperative. Benefiting economically through the violation. I think not paying your penalties, that's a pretty obvious economic benefit. Also not paying to perform mechanical integrity tests, which can cost money. The last is pattern of violation. And I think that's obvious in the non-compliance with regard to the 2 prior enforcement orders, and then just a complete failure to MIT their wells regularly. So I'm happy to go into any of this in further detail, but because the proposed order is unopposed, I kind of wanted to leave it high level. So unless there are any questions, we would ask that you would adopt the proposed order, which is found at Bates page 312.
Suggested language changes.
Yeah. Oh. I figured Kyle had already written it, so.
If we change that one section to shall, then we need to make other changes within the wording.
I think if you just had if you had 5, just say shall, and then if you had another paragraph 6 that went from D down, that could still be may. Would that work?
I think,
so.
would you also want though E, F, and G to be shalls? I don't.
Yes, so the only ones that you would like to maintain discretion over in terms of participation is H, to claim equipment, and D, to use funds.
Yeah.
If you would like to create a new paragraph 6 that included the permissive language for paragraphs, the concepts listed in D and H, that would be great. That would work for me.
I think I would throw A in there too. I'm not sure if we want to immediately declare their wells orphaned.
Question I would have, Commissioner, would it be your intent is if they fail to pay the penalty or return to compliance within 35 days of mailing? Because I think, is that part of the APA that we have to honor that 35 days?
That's why we gave them the 35 days.
Yeah, the director shall.
Yes, I'm not proposing to change anything else about that language in paragraph 5.
Okay.
Except for changing the may to a shall, and then removing subparagraphs A, D, and H, and moving A, D, and H to a permissive additional paragraph.
All right. Is that understandable?
Can I
Okay.
move that without saying it again?
So moved.
Thank you.
I'll look for a second.
Second.
Moved and seconded. Any further discussion? Hearing none, all in favor, please signify by saying aye. Aye. All opposed, same sign. Motion carries. Thank you very much. I think, since I heard earlier that the new commissioner orientation is, yes, sir, being back on.
No, it's not back on, but I want to say that somebody listening carefully on the interweb corrected what I said about OERB. OERB does not plug and abandon wells, they reclaim orphaned well sites. So just to be very clear, they reclaim, don't P&A, but they have spent $100 million since 1994 doing that and have reclaimed 15,400 well sites. So it's still a good model.
Congratulations to the.
Hello.
The
You
listener.
have been conducting a meeting for a long period of time. If you need to
Who pays to plug and abandon?
I know I can find out soon, but I don't know as I sit here.
I think you need to start looking for money.
I know where to start looking.
You're here? The black hole?
No, it's not a black hole.
Thank you, commissioners.
Okay. I do have, my understanding is that we are going to postpone the new commissioner orientation. Do we need to have anything on record as to what we're going to do at the July hearing? Since I'll not be in attendance officially, or can we just take care of that administratively?
Oh, I think we can do it administratively, but I thought you had a good suggestion, which you could put on the record now if you wanted to.
Yeah, would go on record as asking Commissioner Holton to chair the July meeting. If there's,
I think since he's not here, that's a brilliant suggestion.
that was sort of what I thought too.
I think it's a good one, and we can certainly see if we can persuade him to take that on.
It's been called to my attention that we actually did not approve the minutes for the May meeting yet. So I think that's an appropriate matter to consider at this
I
time.
apologize for that oversight. So I'll entertain a motion to approve the minutes from the May meeting.
So made.
Second. I'll second, motion second. All in favor, say aye.
Aye.
Okay, the minutes have been approved. Thank you. I'll endeavor not to do that again. So now we'll entertain a motion to adjourn.
So moved.
Second.
Moved and seconded. Again, all in favor?
Aye.
Aye. We are adjourned.